Good evening and welcome to this session of the Board of Studies live learning classes organized by the Board of Studies of the Institute of Chartered Accountants of India. So, as you know, we've been seeing the economic laws and almost we have seen them. And one of the law that is relevant for chartered accountants is the Arbitration and Conciliation Act 1996. Arbitration and Conciliation Act 1996. As usual, let me set the relevance first before I proceed for the lecture itself. Why is it relevant to me as a chartered accountant? Because again, I repeat this, maybe I made this point earlier also, I will repeat it because the member of the Institute of Chartered Accountants of India is the first point of reference on most financial and legal and compliance matters. First point means there are other professionals who are possibly more competent than us. But when it comes to the first inquiry as to what is to be done in this situation, you will find the client or the management of your company, if you are the senior finance professional there, they would first call you and sort of pick your brain at least. They may not consult you, but they may pick your brain. So it could just be a casual call as to what to do, Srikanth, or what to do, Mr. XYZ, or whoever is here now. We find that there are certain issues, how to, do this. So you will have to have some basic knowledge on what it is all about. In that sense, arbitration and conciliation become very important. Because especially if you are in industry, you will find one of the major problems you will find would be commercial litigation. Repeat this, commercial litigation, that is contractual disputes, especially relating to recovery of debts or mostly recovery of debts or joint ventures or collaborations where there are some serious misunderstandings and people are in the process of fighting with each other. So you will be right in the middle of that as CFO. So you will have to advise your MD, you will have to talk to the other company, you will have to be acting, you will be, to a great extent, you will be acting. If you are smart enough, you will actually be the negotiator or mediator. In which case, you will have to know what is this Arbitration and Conciliation Act. As a member in practice, maybe you wouldn't unless, as a member in practice, you decide to be an arbitrator. Yeah, why not? There's some basic, actually the knowledge of this law is the fundamental. If you know this law well, and you know the practice of this law, and you have certain qualities like impartiality and clarity of thinking, find that you are able to actually do well as an arbitrator. More about it later. So a lot of opportunities. In fact, there were a lot of opportunities. So the late 90s and early 2000s, this was actually sold as a career to many chartered accountants. We were even told that you could take it up and do. But then, see again, as I told you, that's a specialization. So if in case you want to, you can. So arbitration and conciliation, there is no qualification, nothing. Please don't ask me what is the certification program, sir. Is there any nothing? There are certain institutions, arbitral councils that conduct something like training orientation programs. But then, bottom line, it's like you start doing it, you learn, you do better at it, you become better at it, you get a reputation, people keep coming to you, blah, blah. That cycle starts. The vicious cycle of popularity starts. So that, hey, that guy is good, he did this for me. Once the reputation starts, then people come to you and then you become automatically what happens, you keep doing more and more, you become an expert. This is the secret of professional success. So many times I find younger members, especially immediately after qualification, some of you who think, I want to do this, I want to do that. And you will obviously feel a certification course is a passport for all this. That if I attend a certification course and I pay a huge amount to somebody and they give me a piece of paper that says I'm knowledgeable in this particular aspect, that would be a passport for work. You will suddenly find that there are bigger people out there who don't have this paper, but who got experience. Unfortunately, this is the problem. You see, so do give a lot of importance to what is unfortunately called experience, which has, see, the only problem with the experience is that it cannot be done overnight. You need a little bit work on, and you need to work with the relevant master on this. So you need to join a firm or join a senior who is already doing this type of work. Learn from him, be with him, and then slowly grow. It's the only way. So, I mean, sorry to sort of make this comment, but then, so there are a lot of people offering pieces of paper. I am sorry, we keep on using the word pieces. The only valuable piece of paper, I wouldn't call it a piece of paper, only valuable document that you're going to get, and I'm sure all of you are going to get, is the most valuable document in your life. It is the membership certificate to the Institute of Chartered Accountants of India. That is the passport for wherever you want to go. Everything else is pieces of paper. Certification goes in international taxation. Certification goes in India, yes. Pieces of paper. Maybe if you want to increase your knowledge, yes, please go attend. But for that piece of paper, don't attend. If you want to listen to seniors, experts who know, again, that would give you an opportunity to identify those guys who are already there in the field, who are already known experts in the field. Maybe one of them would be kind enough to take you on and teach you, train you. That is how you get this. There is no other way. If you've discovered any other way, I think you can easily locate my link through LinkedIn, my number. Advise me, I will follow. No problem. If you have discovered one quick method, one piece of paper, sir, I will get everything. It's not possible. Maybe it is possible, but be short-lived. It won't be long-lived. So arbitration and conciliation is also like that. It is an experience-based knowledge. Thank you for listening to this, comments that I was giving. Preliminary comments, as I always say. I've got just two people here who sort of put in their good evening. It's Viraj Ji. Welcome, sir. And K. Prashant, of course. Welcome, sir. And welcome to you also. And moving on. Yes, just a small quote to begin with from Auerbach, which says, it's virtually impossible to survive litigation and remain solvent. It's virtually impossible to survive litigation and remain solvent. Solvent means remain with money. The reason is there. But it is occasionally possible to endure it and remain sane. At least if you don't go mad, you are happy. Your money will go, but at least you will be sane. As a modern ordeal by torture, litigation excels. It is exorbitantly expensive. Believe me, I know that. I know it. How you don't ask me. My son is a practicing advocate. Okay, I know what it's all about. It's exorbitantly expensive, agonizingly slow, doesn't happen overnight, and exquisitely designed to avoid any resemblance to fairness or justice. Believe me. Yet, in strange and devious ways, it does settle disputes to everyone's dissatisfaction. Because after the order has come now, one of the person is going to go on appeal. Then again appellate order. Then another appeal. Keep on going. So litigation becomes endless. Litigation means filing a suit in court. Simple. You've sold goods. You've supplied goods to MRN and Limited, and they have also agreed to pay you. Very good. Obviously, when the invoice was there, they accepted, etc., etc. Then goods are there. They use the goods. Subsequently, they refuse to pay. Thereafter, at that point, they keep raising all sorts of nonsense issues, which they didn't raise in the first instance. So you have a valid case against them. So technically, all you need to do is file a suit. Go to an appropriate jurisdictional court. Okay. City, where the money suit can be filed, where the cause of action arises or where the defendant resides, file a suit. The whole matter should take hardly more than 6 months. Everything is there. You produce all the documents, DEC, proof, etc., contract, whatever. They go through it and then they pass an order. It's an order passed by a high court or by a court, magistrate court, is called decree. See, below the high courts, you have magistrate courts. So it's they who hear these matters. You don't go all the way to the high court for this. Only high court has appellate jurisdiction. Writ, it has original jurisdiction. Okay. And in certain matters, pecuniary, that is when the amount involved is very high, the jurisdictional high court has the original jurisdiction, where the first complaint, the plaint itself, is filed with the high court. Normally, for lower valuations, it is before the jurisdictional magistrate, based on the PIN code. Okay, so it's like that. That's called jurisdiction. So why I'm giving this elaborate example, So you file it and then 6 months later you expect an order decree. So all you need to do is take this decree, serve it on the party, and they're supposed to pay. Or you can use this decree, get an order from the execution order. That's another problem. See, that will take time. Forget it. You got a decree, you think you got something, nothing. That decree you have to execute. All sorts of nonsense. But you might think 6 months. By the time you do all this, my dear friends, decree, execution, you're not going to believe this. 6 years. I'm not joking. You don't believe me, go and ask a lawyer. In fact, you would say, who said 6 years? No way. Maybe more than that. That is the problem. Because when two people fight with each other in court, finally who wins? Okay, this is an open question. When two parties fight, they are called litigants. Those who engage in litigation are called litigants. They have filed a suit. One fellow has filed a plaint asking for relief. The other fellow is called the defendant or the respondent. He is going to say why I should not pay or whatever. Most of the time, the defendant rascal will only delay. His lawyer would be paid to delay. The lawyer will come. He will not come. The other lawyer will come. The judge will shamelessly adjourn. The judge will, I'm sorry to use the word shameless, but that's how it is. See, because the other party has not come. Still both are. So this fellow will not object. He will simply say, yeah, we are ready, Your Honor. No, the other party is not ready. What do we do? Another date. Oh, okay, Your Honor. Take it. Because for this hearing, now, when he said, I am ready, he will charge 1 lakh. What did he do? Nothing. Stand up and did nothing. For that, he will charge. Suppose he argues. Gone. For that 2.5 lakhs. Just, that is argument, I say. He actually presented the case. He actually produced documents. He actually argued your case for possibly 20 minutes. Okay. So, I'm trying to tell you that litigation is costly. Shakespeare had a fantastic solution. Okay. The first thing we do, let's kill all the lawyers. That's too drastic. It's not fair. And Shakespeare, Henry VI, okay, who made eponymous. Henry VI himself makes this comment in the play, Henry VI Part 2, Act 4, Scene 2. He says, the first thing we do, let's kill all the lawyers. Because the bleak house, there will be one case. Okay. If that case is settled, about easily 70, 80 people are dependent on the decision in that case. Nobody knows what it is all about. Nobody knows what it is all about. But they know one thing. That case has been going on for 45 years. And all the people, the original litigants are dead. Their children, grandchildren are now there. But all of them know one thing. There's a property in dispute. We are all litigants. In case the order comes, all of us will get something. And based on that, the whole thing goes on. I mean, this is bleak house. Okay. So, good morning. I think it's, I don't know which country you are in. In India, this is evening, 6:15. Because my daughter's father-in-law, he's in Canada. So exactly 8 hours they are behind. So when I call him in the evening, 9 o'clock, it will be morning for him. Okay. So, good. Well, welcome, Ms. Purviben. Chalo. Litigation is expensive, time-consuming, and affects future business relations. Okay. Solution for commercial disputes. Then what is the solution? Let's not waste our time. Because we cannot kill all the lawyers because one lawyer would be my son. So 100% I cannot afford to kill lawyers, go around killing lawyers. Okay. And some lawyers are good. I always say, okay, some of the best lawyers are my friends. And some of my best friends are lawyers. Okay. So I can't do that also. And so solution for commercial disputes then is alternative dispute resolution. Other method, don't go to court, which is where you and I as chartered accountants come into the picture. Because we are going to be the first point of reference. And it is we who can tell them, boss, don't go to court. It is just not worth it. Go for some other alternative method of resolving the dispute. So today we are going to see what is this ADR, alternate or alternative dispute resolution mechanism, ADR mechanism. It's contained not in a single law. Only two are contained in the law we are going to see today. There are four basically alternate dispute redressal methods. Negotiation is purely commercial. It's extrajudicial, extra legal. Means before you do anything at all, you'll negotiate. You'll just go there, you'll talk to each other, am I correct? And tell them, hey, don't do this work. Then there is something called mediation, where somebody more, knowledgeable, senior, or at least knowledgeable, okay, would intervene. He will talk to both the parties. And then he will make them understand, hey, it is better for you not to fight like that. Mediation is called. Mediation is a very powerful technique. Mediation is not covered in the act we are going to see, but it is there. In the most courts actually encourage mediation. That is, even when a case is filed, they see a possibility for mediation, they call a mediator and tell him, boss, there are simple issues. If they give up and adjust and all, we can come out. But what happens is, mediation does not result in total, shall we say, closing the dispute. All that happens is they agree to certain concessions, agree to certain course of conduct in future, and the old agreement, they sort of change it slightly and agree to it, and that becomes what is known as a mediation agreement. The mediation agreement. The mediator produces the mediation agreement, makes them sign it, witness, and that agreement now becomes the method of proceeding forward. So the weakness here is, in case there is a breach of this mediation agreement, again you have dispute. But if the mediator is smart and good, he will come to, I have done a lot of mediations where directors will be fighting with each other, or I had partners will fight. So I used to call them, have a lot of long discussions over cups and cups of coffee, and finally make them understand that, they're killing each other, and then coming to some conclusions. This needs psychological knowledge also. You cannot simply talk only law and all. You have to talk psychology. See, then he has one person ask him to just wait outside in the reception area, and in my cabin, the other man will be there telling him, what is happening? Don't do this, you're a loser. Then I'll do the calculations for him and show. See, today you think for that 5 lakhs or 10 lakhs, you're fighting, but finally you're losing everything. This is the bigger picture. Look at it. Oh, okay, sir, that's point. I'll think it, sir. We'll go off. Then the other guy said, what are you doing, man? This is what. No, sir, that fellow is a rascal. He is a rascal, no doubt. But where are you going with this? We keep on going. Another 2 years down the line, what will happen? Further loss only for you. You would have wasted interest to accumulate. Why are you wasting your time? Finish it. Bring an end to your problem. Start fresh. Leave him. Let him go. He's asking for 10 lakhs. Give it. You are saying 20. He's saying 30. We will negotiate. There we can talk about 25. Finish it. Go. See, this is the beauty of mediation. So finally, if they all come and agree, then we have to put it in writing. And then execute. Beautifully, they have done it. And both parties have come back to me and said, sir, thank you. We are now happily running our own business. And for all they may become friends also. Okay. Conciliation. It's slightly different. We will see that. That is part of this law. Conciliation. We will see that. And conciliation and arbitration are just one below each other. Arbitration is the final. Why? Why arbitration is so great? Because an arbitral tribunal passes an order which is equal to a decree of a court. I repeat, the order passed by the arbitral tribunal. The order passed by the arbitral tribunal is called award. Arbitral award. This arbitral award is very powerful. Unless there are some lapses in the manner in which the arbitration was conducted, unless there are certain lapses in the manner in which the arbitration was conducted, that is all. You can only object to that. Other than that, on merit, whatever arbitral award says is final. You can't appeal against it. There is no appeal. You can go to the High Court only. I'll come to that point, and that's the most important part of this whole topic. The questions will come mainly from there. When can an arbitral award be appealed? Only when you are able to show that there are certain procedural lapses in the way in which either the independence of the arbitrator or the time was not given or what. There you go, you have a chance. But no, he has given 5 lakhs where actually it should be 6 lakhs. Baba, he has done it. Whatever he heard, you are all there. Arbitral award passed now. That's why you went for arbitration. Am I correct? That's why you went for arbitration. Whatever he is doing, you have to be happy. See, think about it. Look at this example. More as a story only I'm telling. There was a farmer. Don't use the word out of the court settlement in this context. Words are very, very carefully to be used when we come to law. Don't use the word out of the court. Arbitration is before the court settlement or without the court settlement. I'm making it very clear to you. Without the court. Are you able to understand? Without the court. And or before the court itself. That is, you don't go to court at all. You go to an arbitrator. He does everything. Court doesn't come into the picture at all. So you don't say out of the court. I'll tell you why. Because what is out of the court, you know? Two people are fighting. There is some sort of a dispute. Court is hearing the matter. Court is hearing. Case is numbered. Hearings are going on. At that point in time, one advocate goes to the other advocate and says, my party wishes to talk. Then they go to the court and say, sir, we want to talk and settle it out of the court. Then the court will say, go. Come back with your agreement. We will see. I will see what I can do. All this is happening under the court. Please don't. And that too with the two lawyers. Then the lawyers sort of, whatever they do, finally the party says, because there is a kind, it looks a lot like conciliation and arbitration, but it is lawyers who do it. And it's all done. Finally, they go back to the court and say, this is what we have come to. That will get incorporated in the order. It's an agreed order, where both have agreed and they said, we will not further go. Think about it. It's very, very difficult. And generally, lawyers will shy away from it. They will do it only when there is no other go. Out of the court settlement, they will go. So don't, out of the court settlement through mutual consent is possible. It is good. But that is not arbitration. I will not define arbitration in these words. You get my point? I appreciate your need to say something, but when you're saying it, be careful what you're saying. Because arbitration is a totally different process. It agreed, there is no court involved at all. Whereas in out of the court settlement, court is already appraised of the matter. Now, it is quite possible that a case may be filed. While the case is pending before the High Court, one party may invoke an arbitration clause. That is also possible. Then the court will direct the matter to be completed by arbitration. That's all. And then finally, when the arbitral award is received, that award will be taken to the court and closed. But that is not out of the court, because again, arbitral award will be there. And arbitration council will hear the matter. Whereas out of the court settlement means two parties decide, almost, out of the court settlement will come back to negotiation. Lawyer guided negotiation, like that we can say. And then finally the lawyers will say, you do it. And then mainly this will out of the court settlement happens in damage. You keep fighting, man, you are asking for 20 crore. 100% we'll go on appeal. By the time you get 20 crore, you will die. Like that, no, they'll threaten him. They'll talk when they come home. Then this lawyer will go to him and say, okay, what is correct? So then this guy will ask, what can you get me? They'll go back to the insurance company, find out. This is how out of the court settlement happens. Don't confuse out of the court with arbitration. So any alternate dispute redressal gives us lower costs with greater flexibility. That is important. I wouldn't technically say lower costs. Actually, I would add one more word there. I would say relatively lower costs. It is not as if arbitral counsels come cheap. Because remember, where do they come from? They are again lawyers who have become judges, retired. So it's not as if they are cheap. They are costly, but relatively lower costs with greater flexibility. Boss, if you appeared before a court, you will know. I'll tell you, my son filed a suit before the lower court on rent control, under the Rent Control Act. He got the order. Power of attorney was not something silly. Power of attorney, based on which this case was filed, was not notarized or something like that. Something like that. And not raised like that. So my son gets the order in his favor, in favor of his client. And the matter is over. But the case was filed by the power of attorney holder, that was not notarized or something like that. That's all. That is the matter. The other party goes on appeal. Can you imagine? Just because it was not notarized, it goes on appeal. But my son again appeared before High Court and he argued it. He said, this is not a matter. You should have objected it at the time when it was shown to you. Now, just for the sake of dragging, you are doing it. High Court heard it favorably and they dismissed the appeal. But all I am trying to say is, such silly things and all can drag. Whereas in arbitration and all, this can't do. You can't arbitral award, they say, okay, it is not notarized. Now go and get it notarized. Matter over. The High Court can't do that. And send it back to the lower court. It will take another 2 years. Friends, most lawyers are superb in delaying. In fact, most defendants want delay. Why I say defendant? Because defendant is simple. He took goods for 1 crore, he is not paying. Okay, you file a case. The longer you delay, the better off he is. Am I correct? So, higher confidentiality. Okay? Because most court hearings happen, why most? All court hearings, except possibly some family cases and certain child involved cases will be in camera, where nobody can be there, only the parties will be there. Other than that, everything happens open in front of everybody. Okay, everybody will be sitting, audience will be there in front. I don't know, recently one Malayalam movie was there, where on divorce case, the judge will be firing the guy and his brother and all, in front of everybody. It will happen open. It will be happening open court. Everybody will be seeing what's happening. So there's a lot of confidentiality in arbitration, especially for corporates, this confidentiality becomes relevant. Greater likelihood of settlement. Believe me. Again, I will add one more word here. Greater likelihood of early settlement. Because ultimately, court also will give some relief. But by the time it comes, it is of no use. That's why they said you will survive litigation if you are happy with sanity. But finally, to everyone's dissatisfaction. Okay? Very slow. I think I skipped, but not a great thing. Okay? We are already here and now we are moving on. Choice of forum and solutions are with the parties. The parties can choose who will hear. They can even give some suggestions. These are our disputes. They can even say specifically tell us, that's all, you decide this and go, rest of it don't bother. This you tell. For example, quality cases could come up for arbitration. Means goods were supplied but rejected on account of quality. So one party says, no, my quality was as per what you told. And the other party says, no, we can't settle. Usually it will be, say, Indian Railways will be the other buyer. Supplier would be some manufacturing company. They would have, it's okay. Now, who can settle this dispute? Definitely not an advocate. Maybe an experienced chartered accountant, along with you need an engineer, which is why chartered engineers are there in the arbitral panels. Who has experience in engineering only can come and sit here. So all he has to do is go through these items, see what is there, see what is the spec, see what has happened, examine, and then come out with his view. This could be argued. They could say, no, sir, there will be an issue. But finally, he can come out, he will be more clearer on what it is, rather than an expert opinion as a witness. No, he himself is the arbitrator. So he can decide faster. That's the point. Otherwise, what will happen? Everybody will bring expert. Here also experts can be bought. But the man sitting here himself is an expert. Similarly, a chartered accountant sitting on certain financial disputes will have far more clarity on balance sheets. He will say, what is this? What happened? Where is this? Bring me. So he will know what he's talking about. He would not be wasting time. So choice of forum and solutions. Of course, as in most cases, there are, when you say advantages, there are disadvantages also. There's a requirement of cooperative behavior of both parties. See, since it is more flexible, you cannot behave like a court. You need a little more cooperation. You should produce documents. You should be on time. See, suppose an arbitration hearing has come, you should be there. You can't take time. After all, so much effort and time and money. You have to hire the hall. You have to, arbitration hall is there. There are arbitration councils who hire out halls. Then you need to hire the arbitrators from the panel. They have to come. Other advocates are going to charge. The other advocate is going to charge. Advocates are allowed very much. It's not that advocates are not allowed. Parties have to come. Documents have to be brought. Clerical staff have to come. So many things are there. So keeping that in mind, everybody should be punctual and on time and things like that. There is a certain power imbalance between parties, in the sense, I gave you an example, railways versus supplier. Always railways is superior, but even then, a very impartial arbitrator can. Sometimes the engineer, the chief executive engineer himself will be the arbitrator. But that's okay, so long as he's got clarity. Janvi, we will not jump the gun at this stage. This is an introductory statement I made. It's a very elaborate section 32. I will be coming to that. At that time, I will tell you on what matters alone you can file. So your question, appeal cannot be filed against decision of arbitrator in case any of the parties not satisfied with things like that. Madam, your question is a double-pronged sword. I don't know how to answer it. Because on merits, no. On merits, no. On the subject matter of the case, no. But you have used one more word. Conclusion is biased. No. You cannot say conclusion is biased. Whatever conclusion is, but if you are able to show reasons why his conclusion could be biased. For example, he has an interest in the matter. He knows one of the parties. He has appeared for one of the parties. He was earlier a mediator in the matter. Anything like that, which could cloud his opinion, if you are able to show, then you can go on appeal. Again and again, I'm repeating. Most of you are eager to make statements and ask questions, but you're not listening to what I'm saying. Appeal is possible only when you're able to show that there is a procedural lapse in the manner in which the arbitration was conducted. So bias cannot be simply, you cannot say there is a bias. Prove how the bias could have happened. If suppose the man has no connection, the man has no link with any party, he is a well-known person and he is not been, then whatever order he has given finally is finally. Because it is against you, it cannot be biased. See, because it's obviously when there are two parties, when I say you, I mean one party, not you. Okay. And there are two parties, an order cannot satisfy both. Yeah. So it will definitely may swing in favor of one. In which case, the other party would obviously say it is biased. Sorry, that cannot be a reason for appeal. But you show that there is a valid reason why. For example, on one matter, which was pending before the High Court, I was appointed by one of the lawyers to conduct an audit and report on the whole matter. There was a fraud by one partner, cheating the other partner by booking false expenses and all. And that was not the main case was about possession of the building and all that. But in that, this was also written. He claimed certain amount as due, whereas this party was saying, no, it's not due. That is all fraud. So for that, the lawyer got, I gave a detailed, I did a forensic audit. We came out with a detailed report wherein we clearly identified some, I think about 85 or 90 lakhs was clearly bogus without any bills. Some double claims. The same bill was being claimed 2 times like that and all. So finally, we gave our report. That report was taken by the court, etc., etc. But on certain other matters, it got thing. So at that point in time, the court said, hey, if you want to go for arbitration, go. So an arbitrator was to be appointed. So the lawyer now, had to appoint an arbitrator. Now what happened? By then, the lawyer had changed. On appeal, the lawyer had changed. The old lawyer was not there. The new lawyer came. The new lawyer knows me well. And he went through many people. Finally, I got a call from him. And he said, Mr. Srikanth, I heard about you. Would you be able to act as one of the arbitrators for that? I said, definitely. Property dispute. Okay, where is the property? He said a location. Immediately I asked him, is it this property? Yes, that property. 9th floor, 10th floor matter. Yes, that property matter only. Sir, I cannot be an arbitrator. Kyun? Because I've already given a report. I've already given a report which says that there's a fraud by one party. Obviously, I'm biased. I cannot be an arbitrator. Now, I have to recuse myself. If in spite of that, I say I will be impartial, I'll come and I'll say 100% the award will get disputed. 100%. I told him, boss. No, Srikanth, I totally agree with what you're saying. Even if you are impartial, it's not going to work. Because the fact that you are associated with the matter, out. So on those matters, you can say. I hope you have understood, Janviji. And don't go there now. When you come to 32, you will see clearly the law has given. These matters only you can go. Others, nothing else you can go. So take it from me that 32 is there. Okay, if that doubt you have to believe me. Also, the logic behind it is there should be men are mortal. Their dispute should not become immortal. I say somewhere there should be an end to the issue. That is the logic behind this alternate dispute. Bring an end to Kar Vivad Samadhan. Kar Vivad Samadhan. That is the statement given by the so-called income tax department for allowing people. Vivad se Vishwas now. Earlier it was Kar Vivad Samadhan. Okay, let us make peace in our argument. Now it is Vivad se Vishwas. Okay, which is even better scheme than Kar Vivad Samadhan. KVS game longer, VS. So whatever it is, let's stop fighting. I will give some concessions. Take it. Pay. Close. Chal. Let's live life. That is the concept on which arbitration should be happening. Okay. Lack of interim measures. Yes. See, there is something called status quo. There is something called status quo. See, some of what I am telling today, you might find, if you ask me, Mr. Srikanth, where is it in the exam paper? Will it come? I am not able to answer you straight away. But if you think it's relevant to you as a future, matured, all-rounded professional, yes. Look at the story. See, the story, it's an interesting story and it has a link with what it is. What is an interim measure? Simple, sir, land dispute, sir. What has happened? A has a land. I don't know what you say, about 10 cents. I don't know, in India, there are ground. In Tamil, in Chennai, we say ground. In Coimbatore, they speak cent. I don't know, some other places, whatever you say. So depending on that, whatever it is, let us say Coimbatore, one land is there. Okay, 15 cents. Adjacently, there is another plot, 25 cents. 15 cents owned by A, 25 cents owned by B. Adjacent. Next. Okay, Aspas. Now what happens? Our man A, 15 cent fellow, quietly in the night he comes and pushes the, those markers will be there, the buried markers will be. He pushes it and goes. So once he pushes it, next day or 2 months later, our man, this B comes and says, hey, what happened? No, that was always mine. Yeah, when did it become like that? You will start giving dispute. No, when did it become? It was mine like that. They'll keep measuring, talking, disputing, fighting, hitting each other. And this one will say, my grandfather bought it from your grandfather. The deed is there with me. Produce it. I will produce it. Not now. Like that, all arguments will happen. But so this is one matter. Like now they go to court. Now, when they go to court, who will file a suit? B will file a suit because A has only encroached as per B. So A will file a suit. Now, when A is filing a suit, first thing he will do is file for interim relief. What is that? Temporary injunction. For what? He'll say, look here, I was in quiet possession of this 5 cents. I was completely in quiet possession of the 5 cents. I have proof for it. I have a sale deed, everything. Diagram is there, picture is there, everything. But now he says it is his. Let him prove it. This case will go on. I'm not questioning the case. But in the meantime, the land which I was quietly enjoying should continue to be in my possession. So give me an order of temporary injunction, which says, directs him to move back this land. Later on, let the matter be decided. Then, whatever happens, I will do. At that time, I'll take it. Now, this is the argument that the lawyer of A will put forth, B will put forth to the court. And the court generally will look at all the papers and say, chalo, let us maintain status quo. Before this was started, how much you had? He had 25, you had 15, now go back. We will decide whether this 5 belongs to you or him. Once we say it belongs to him, then he will come. B can come. But if it says it's not belonging, then A can come. Otherwise, if it says no, then wherever you are is wherever you are. That is called status quo. Such orders of injunction are meant to maintain status quo. That type of a relief cannot be given by an arbitrator. It's simply beyond the scope. See, this power is available in interlocutory applications, interim injunctions. The power is available under the Civil Procedure Code. And it's available only to the court, magistrate or whichever court. The Arbitral Council does not have interim powers, interim measure. Okay. And finally, of course, there is difficulty in enforcement. Actually, there is no difficulty because once the arbitral award is come, you take it to the court and the court will take it on record and then it can be executed as if it's a decree of the jurisdictional high court. There is no question of that. But as I told you, the minute the arbitral award comes, no one of them will be unsatisfied. Immediately, like John Vijay was saying, it is biased, like that, they will go. How to prove it? They will cook up some beautiful ways of showing that he was biased. Why they didn't tell it at that time itself? No. We'll see more about it when we come to selection of arbitral panel. So that is why mainly at the time of selection of the arbitral panel, you have to be very careful. See to it that you get a guy or a lady who had no connection with the matter previously. Only then it will be safe. So there are 3 categories. Mediation, arbitration, conciliation. Also, we have something called Lok Adalat and permanent Lok Adalats, which are meant for panchayat level and rural level land disposal. They can settle instead of going to court and all. So that comes under the Legal Services Authorities Act 87. They have set up Lok Adalats and permanent Lok Adalats and all that. Then you have the Civil Procedure Code. Okay. Under the Civil Procedure Code, high courts are empowered to set up mediation. When the court case is pending before the court, under the Civil Procedure Code itself, they can authorize mediation. So the mediation panel, empaneled mediators will be there in the High Court. Again, senior advocates or advocates with experience. Chartered accountants can also get enrolled as mediators. You have to go to the appropriate court. I think you have to attend some course. I mean, that is an orientation course, not a certification course. Orientation course. Membership to the Institute of Chartered Accountants is a criteria. If that is the passport. Then they will say, kindly attend this orientation. So they'll teach you what is mediation. It's just like that. Then you'll have to be on the panel and wait in front of the court. Sir, please give me some. So there, who will give you? You'll have to get, suddenly it will come. Somebody, you'll have to be friendly with advocates. Just go around talking to them. And then they'll say, okay, take it, they'll throw. You do a good job there, you prove it. Next time it comes. That is how it goes. Okay. Now, then of course you have the Arbitration and Conciliation Act, 1996, where that facilitates arbitration and conciliation. That is the subject of today's session. Okay. So the Arbitration and Conciliation Act, 1996. The act consists of 4 parts. First part deals with arbitration, your domestic arbitration, and in international arbitration also. Second part deals with enforcement of certain foreign awards. See, when we come to the next point, you will understand this. The third part deals with conciliation. And the fourth part deals with certain supplementary provisions. If you want to read the entire arbitration conciliation list, the other day somebody was asking me, I know who it was, sir, how about those sections and all that? Don't do that. Only the important sections are enough. I'm covering it for you. Whatever is relevant is here. Okay. That way, if you want to read the entire law, the Bar Act is there. You can, I'm sure you can go through it in the instrumental, but not so. Because this is, remember, if you see the marks allotment, this won't get that much marks allotment. This topic is a very, very peripheral topic. Peripheral means in the extreme edge. It is not a core topic as an opposite of core. Core is right in the middle. This is peripheral. So they could ask a question. They may not even ask. Usually ask one question. One question, sure. So for that, what you must know, basics of it, you should know. Right? So that much is being taught here. Okay. So if somebody is attempting to be thorough in every section in the syllabus, every section, simple logic that person has is this. Sir, there are only so many sections in the Companies Act, sir, in the syllabus. There are only so many other sections in the other laws and all, sir. Suppose I systematically read everything and memorize it. How can I not get 100, sir? You are absolutely, logic is correct, but it's not possible. Waste of time. Rather, study the important parts. Look where the weightage is more. Study that deeper. Okay. I've already given you this idea earlier. If not, kindly take it now. Okay. You might ask me, who are you to say all these things? We know better. We are totally agree with you. But all India rank holder 2 times. Okay. How? Without studying. Not studying all the sections, everything. No. Yes, but I studied. Okay. I spent value time on my studies. I was not a casual fellow. I studied and I wrote both the groups together and I got not less than 60 in all subjects. How? That is all I'm trying to share with you. Don't think otherwise. Some of you may get angry with me. Please don't get angry with me. Idea is not to say what you're doing is wrong. What you're doing is correct. You study everything. Definitely out of that only, the syllabus only, the question should come now. But do you have the time for that? To read other subjects, to mix and match. So many subjects are there. And so that is why some of us have decided that we will not study everything, but rather only the crux part. We will understand it. The exam, definitely that they cannot afford not to ask. So they will ask you. And when they ask you, you know the answer. Like that. This was understood. That is why many books which came, I will not mention authors' names, including me. I was the first man to write a book for final in the old syllabus. That is when it was the 1956 Act. It was called Corporate and Allied Laws. I wrote a book. At that time, to my knowledge, I was the first man to provide questions along with the chapters. After every chapter, I used to give the questions. Thereafter, in my second edition, what I did, every subtopic I used to give. For example, casual vacancy. After covering casual vacancy, all the exam questions related to casual vacancy will be answered. So that student can easily find out which is important, which is not important, and proceed. So that pattern started then getting very elaborately adopted by other book writers. And I became very with this practice, so I sort of floated. So that methodology became very popular. So much so, that institute itself introduced what is known as the practice manual. The institute introduced the practice manual, seeing that, oh, question answer, topic-wise analyzed question answer is needed by students. So they gave it. Okay. So in the meantime, of course, our friend Arun Sachdeva was there, Dr. Arun Sachdeva, scanner, banner and all. That was there. But in 1987, when I wrote my final examination, when I was 20 years, 8 months, you can say. 20 years, 8 months. Not yet completed 21. When I was preparing for my CA final, there was no scanner. So what we used to do, we used to take all the side answers, we used to collect it, and we used to 20 side answers and then do ledger posting, topic quiz, and see which question, how many marks, which topic, then go. Then after all that analysis is done only, we will decide which has got more weightage, which has got density, then we'll say that we will study more and all that. Of course, this approach may sound very wrong to some of you who believe that you have to start with the first chapter, first line of the institute material, go to the last chapter, last line. That is how preparation, sir. That means I have prepared, sir. Otherwise, I'm not prepared, sir. Like that, if you think, sorry, I'm not possibly helping you. But if you, little bit also, if you understood what I said now, you will know what to do. Okay. Good. In fact, my PowerPoint presentations are prepared in that way only. I will take each section and see which is the crux. What is the important concept here? What is it that students should know that institute cannot afford not to test him on? Stress that. Okay. Is the point. Chalo. So, the act is, as against there is a preamble says this act is meant to consolidate and amend. Consolidate, bring together, consolidate and amend. Already existing Arbitration Act was there. The earlier Arbitration the Arbitration Act 1948 was there. For your information, the Arbitration Act 1948. Conciliation was not part of this. Then it got amended, included. Also, they wanted to include the new law relating to international commercial arbitration, based on the UNCITRAL model. See, the United Nations has a treaty on law. So we are many laws, intellectual property rights, arbitration, contract itself. There are certain international models that we have agreed, that we said we will also follow. We have aligned ourselves with the international legal fraternity, and we have signed treaties to that effect. Okay, so that is incorporated in this law. This Arbitration Conciliation Act incorporates the internationally accepted methodology for arbitration and international commercial arbitration. Also, suppose there is an award which was obtained in a foreign arbitral tribunal. Okay, that award can be enforced as a decree in India under this law. Otherwise, there is no confidence, you see. See, suppose a company is coming to do business in India, they're selling goods, especially when you're selling goods. You see, when you're buying, okay, when you're selling goods, you need assurance that you can collect. And this is something that, or when you're entering into a contract for supply of goods, you should be assured that the quality will be supplied. Whatever. If there is a dispute, what can I do? So I can file a arbitration. I can go to an arbitration. Can I enforce it here? Yes, you can. To define the law relating to conciliation also, other incidental matters. Just to give a quick background, as I told you, the UNCITRAL model law, okay, the United Nations Commission on International Trade Law, it's called UNCITRAL, has adopted the UNCITRAL model law on international commercial arbitration in 1985. Okay, so that means that we are now party to the international treaty. And so based on this law, is based on the UNCITRAL model. What happened? The United Nations, they gave a model law and model rules, model law and rules. And they said, as best as possible, try to ensure that your law, in India, aligns with this, which is why we needed to create a totally new law called the Arbitration Conciliation Act. The earlier Arbitration Act 1948, we had to get a new law Of course, when I prepared for my examination, CS, Company Secretary, it was Arbitration Act 1948. I passed in Arbitration Act 1948. Then 96 came. I taught 96 to the company secretaries. When the new law came, I taught it to the company secretaries first. The company secretary institute, I taught it. And I used to teach. Then I still teach arbitration sometimes. Arbitration conciliation. New law. Okay. But basically it's the same. And one thing I'll tell you, the 32 has not changed again. That appeal is not changed. The same old thing. You can go on appeal, and that is the bane of this law. I'll tell you. I mean, if you don't believe me, if you have a lawyer cousin or an uncle who's a lawyer, you tell one. Srikanth was telling sir that this is the bane of all arbitral awards. That any arbitral award will be challenged. Absolutely correct. What is the use of going to arbitration like that? They will tell. Chalo. So basically, the disputes are referred to an agreed arbitral tribunal and not a court. The result is a binding award which operates like a decision of the court, which is called decree. It presents an alternative to litigation. It does not suffer from the rigidity of proceedings. The CPC doesn't apply, which means you can stand up and talk freely. And also you can file a document at any time. See, you have to, if you want a document to be considered as evidence in a court, it has to be filed. It has to be taken on record. Then it has to be given to the other party. Then only one hearing will be there only for taking it on record. Can you imagine? One hearing only for taking it on record. That could be, then he will come out with his argument. That fellow will come out and he has to say nothing. We don't object. Let it come. That will be another hearing. And then the case will go on with this evidence also. So if you want to introduce evidence in the middle, no, please don't do that. That's why lawyers are, that is one of the reasons why lawyers are a bit slow in filing, because give me all the documents. Everything should be there. See, you can't make a statement in a plaint without supporting documenting. See, you can make a statement just like that. You can make a statement. You can make one statement. Srikanth is a fool like that. You can tell nothing wrong. Tell, but you have to give proof. Document should be there. Everything should be there. You can't make casual statements. Okay. For example, number 21, Indraprastha mark belongs to me. You can say, yeah, agreed. Give proof. So, whereas the plaintiff avers that this the schedule mentioned property was in his possession and ownership and possession since so and so date. Okay, you aver it now. Proof. Whereas the plaintiff avers that this is evidenced by the document of title, which is here as hearings are there. These two documents are going to stand up and one fellow is going to introduce it. For that, he will charge you 5 lakhs. The other fellow is not going to object. For that, he will charge 2 lakhs. To his client. Okay, I asked an earlier question. When two litigants are fighting, who is the ultimate winner? Anybody can give an answer? Because I don't see any comments coming for a long time. So here's an open question to the audience. When two litigants are fighting in the court of law, who will be the ultimate winner? Anybody? I want to know whether you guys have got that type of lateral thinking idea. Let us see. Two people, A and B, are fighting against each other. Who will be the ultimate winner in that case? Okay. When two litigants are fighting in a court of law, who will be the ultimate winner? John, we got the point. It is not one liar, both liars. Why only one liar? Both liars. Both liars will win. Okay, judge will get his salary. No doubt about it. Litigant will get what? Nothing. It will simply get an order. Finally, what is the use of that order? Sorry, I'm being very derisive of the legal profession. Though my own son his career option was that from 8th standard, he was keen on becoming an advocate. And he wrote his CLAD and all, and then he joined Christ College in Bangalore, and then he is now a practicing advocate with an international law firm in Chennai, where he is an associate. He keeps going to lower courts and high court and all, and he loves litigation. Morning, he gets up, wears the coat, and he parks the car in Chengalpet High Court or Tiruvannamalai High Court or Madras High Court, Tiruvannamalai Court, and he'll simply argue, go there, argue. He likes that. That's what gives him energy. Okay. Good. So, arbitration is a method of dispute resolution involving one or more neutral third persons selected by the disputing parties and whose decision is binding. So, in a way, this is not a definition. This is a description of arbitration. It is a method of dispute resolution involving one or more. Single arbitrator possible, chalta hai. Or two also possible, we'll see, but two generally avoided, but three. Odd numbers are preferred rather than even, for obvious reason that even could result in a tie. Okay, and who will break the tie? So prefer an odd. So, but then that's not a strict rule. Immediately, Janviji, don't jump. That's not a strict rule. It is possible to have even also. Okay, but preferably not. So arbitration is the method of dispute resolution involving one or more neutral third persons, unconnected, selected by the disputing parties and who's. See, simple. This is what I'm telling is not an example of arbitration, but it is an example of litigation. See, Amit Bhai and Ajit Bhai are fighting. Brothers fighting. Father has left 3 properties, 2 sons. There are 2 property, 2 sons, value equal. Such fathers are rarely to be found. 3 properties, uneven value. Who will take what? Ajit Bhai, Amit Bhai, fighting. Daily fighting. Okay? Jamnagar mein. Right? Or Porbandar mein. Wherever. Fighting. Okay. Fighting means what? They won't even also fight. No, the Gujaratis won't fight also. They are getting. So nothing is happening. Neither of them is enjoying. They are all living in some small house, whereas those 3 bungalows are sitting there, father's property, not able to use. So now they can, they call their uncle. Okay, Chachaji is coming. He said, Chachaji, you please advise us. What to do now? Father is no more. What to do now? So he says, Beta, oh, here, sit down. Come on, let us talk about it. Then who's your father? What happened? Your uncle? You know that this property, how your grandfather bought it, how your father, all that. You know how it is. Don't waste time. What is it? So value one property. This is the valuation. You pay him so much. You take the property. Or you pay him so much. Take the property. Or both of you sell it. Take part. Keep the other 2 properties. Like some solution. So, no, this, that, 2 or 3 days. Finally, Chachaji comes out with a better solution. Then they also obey because Chachaji is telling us, so thank you, sir. They're happy. They go. Okay, here Chachaji does it because he's an uncle. He doesn't do it for money. But in arbitration, they charge. The arbitral panel will charge you for that time. But the approach is the same. Everybody will be allowed to talk freely. In case somebody is getting emotional, Chachaji will say, hey, wait, no. Let's relax. Okay. Shanti. And then again they'll go on with the discussion. See, this is what it's all about. Okay. Arbitration. Because mediation and arbitration sort of cousin brothers. You cannot say when mediation, but there are some clear differences. I'll tell you what it is. Clear. But one difference is clear now. Mediation results in mediation agreement only. Chachaji's verdict is not an award. It's because he's not arbitral tribunal. Understand? Chachaji's final conclusion and says, hey, aisa karo. That is not an arbitral award. That is at best a mediation agreement. Possibly oral. Better to be in writing. Okay? That is again because there will be a problem. Because this Chachaji matter will become another dispute in the court. You know, at that time when Chachaji told you agreed, no, like that you'll say, hey, where is it in writing, man? That's so mediation should always result in a written mediation agreement by which these parties agreed to abide. But arbitral award is a decree. It can be enforced. That is the basic reason mediation. So the Chachaji example I gave is more of a mediation than an arbitration. But the principles are the same. Except that arbitration will be little more formal. It will happen in a more formal setup. There will be a big hall where 2 sides will be there, lawyers will be there, almost like a court. But court behavior, no. It will be easy going. Okay. Arbitration means, one more thing. I may be subject to correction, but arbitral counsel does not have the power to recognize contempt. Whereas court, if you don't obey the order of the court, it's contempt of court. Remember, if you don't obey the order of a court, it is contempt. For example, many income tax officers, when they passed in this faceless assessment, they passed famously foolish orders. Immediately assessees went to high courts and they got a order that immediately such silly orders cannot be entertained. So they quashed the order and said, redo it. But the officers did not take action for redoing. immediately contempt action started on. So we have sent you a letter saying do it within 3 months. Have you started re-hearing the case? What? Report on progress. No report. Then contempt proceedings. Then that concerned officer had to pay. Concerned officer, government won't pay for him. 1 lakh he had to pay for contempt, which is a separate proceeding. Nothing to do with the main proceedings. Contempt is a criminal proceeding. 2 years imprisonment, if persistently. So this time the court let off with a fine. Otherwise they put in prison. But arbitral award, no. They can't do all that. But what you should do, you take that award, go to court, and you file it, and then take it as a decree, enforce it as a decree. Thereafter, if it is not obeyed, that becomes a contempt straight away. So arbitration means any arbitration, whether or not administered by permanent arbitral institution. In India, the government has encouraged the setting up of permanent arbitral institutions, which will administer and monitor arbitration. But that is not compulsory. But if it is there, it is good. If not, no. So arbitral institution means an arbitral institution designated by the Supreme Court or High Court. So like that, they have set up arbitral institutions. For example, we have in Chennai, we have Nani Palkiwala Arbitral Institution, which is famous. So the famous, advocate Nani Palkiwala's name, they have started where the arbitration is done, where the arbitration panel is there. So if anybody wants to have arbitration done, they can hire the hall. They can take arbitrators from the panel available with the council, and they can do it. Okay. So arbitral tribunal means a sole arbitrator or a panel of arbitrators. Court is the principal civil court of original jurisdiction in a district. That's why I said all cases will not be filed before the High Court. It will be filed before the district magistrate or the city metropolitan magistrate. Okay. It includes the High Court in the exercise of its ordinary original civil jurisdiction. I told you, in some cases where the pecuniary matter means money value is high. I'm not exactly aware of the pecuniary limits of High Court. Seriously. CPC and all, last time I taught CPC, last time about 20 years ago, I taught. At that time I knew, but now I don't remember. Maybe they would have changed it a lot. Whatever it is, it will be a huge amount. If the value is above that amount, you go directly to the High Court on the original civil jurisdiction. Or if you are not happy with the order of the magistrate, district magistrate or metropolitan magistrate, then you go for an appeal. Either way, High Court has both original and there's original jurisdiction, appellate jurisdiction, and writ jurisdiction. On a writ also, 3 jurisdictions are there. Of course, this does not include any civil court of a grade inferior to the aforesaid. Okay, and any court of small causes. There are some smaller courts than this, which will not come under this category. Okay. Arbitral award includes interim award. Don't confuse this with interim relief. Interim relief is like injunction, stay and all. This is interim award. That is, if, for example, they will say, look here, the quality is disputed. You owe him 1 crore. Let us come to one simple conclusion. Are you going to reject it or are you going to accept it? No, we are not rejecting it. Then how much are you accepting now? No, we are not. So then let's come to a point. No. According to us, if you say that he is eligible, he is claiming 100 rupees. We are saying up to 80, he definitely is entitled. Give that 80 to him. Now, the balance 20, how much is due, we will decide. Because the defect is going to be only there, that part. We will decide how much is the defect. If at all you have to pay balance or not, or if you have to pay how much and all that, we will decide. So this 80 you pay immediately. That is called interim award. So that at least the fellow will get some relief. Now see, he's owed. Because there's a small dispute, why are you keeping the balance payment? Give it to him. No, wait, don't give this 20. Keep it pending. We will decide. Then we will say this much is the amount to be cut off. You cut it and give it to him. That is an award, final award. Okay. Then you have something called international commercial arbitration. Okay. It is an arbitration relating to disputes arising out of legal relationship. The relationship may be contractual or not. Okay. Why they say legal relationship? Because even suppose there is some damages, then though there is no contractual, there is a legal. See, A was having a factory in Bhopal. One company was having a factory in Bhopal. And there was a guy, very, very long ago, Bhopal gas tragedy. So people are affected. There is a dispute there. But it arises out of a legal relationship called tort. But it is not contractual, non-contractual. So arbitration relating to dispute. It should be considered as commercial under the law in force in India. And at least one of the parties in India should be an individual who is a national of any other country other than India, or an individual who is habitually resident in any country other than India. A body corporate which is incorporated in any country other than India. A company or an association or a body of individuals whose central management and control is exercised in any country other than India. So, for example, in this particular case, I forget the name of the Bhopal tragedy. I forget the name of the company. It's just missing. Bhopal gas tragedy. I forget the name of the company. Okay. So, fertilizer company. Forget the name of the company. So, the company, they were... So the company's basic core management, central management was outside India, right? So, or the government of a foreign country itself can become a subject of international commercial arbitration. So this particular diagram that you are seeing is a sort of a brief summary of how arbitral proceedings or the process of arbitration works. So don't start at the top, start at the bottom. It all begins with two parties, party 1 and party 2, who have a dispute. So there they do not have consensus ad idem. There is a dispute. But on one matter they have consensus ad idem. What is that? That they will refer their dispute to arbitration. Are you able to understand consensus ad idem? The parties are clearly having consensus ad idem on one matter. What is that? That they will refer the matter to an arbitral council, tribunal. Also, they come together and based on whether it's an arbitral clause or whether it's an arbitral agreement, they appoint the arbitral tribunal. For example, party 1 will appoint one tribunal. Ideally, party 1 and 2 come to a conclusion on who it should be, single arbitrator. Both of them agreed on one man. Now, it may not be possible. So, party 1 will agree on one man, party 2 will agree on another. Then 1 and 2 together will elect the chief arbitrator, third arbitrator or chief arbitrator. That is one method. Like that. Suppose the matter is very complicated and it needs more people, then 2-2-1-5, 3-3-1-7, like that. Okay, so that is how it is. The more arbitrators, more money. So depending on the dispute, depending on the complication, depending on the need for more brains to work on this. Okay, whatever it is, the arbitral tribunal is formed. Ideally, the arbitral tribunal should be independent, should not have any connection with the dispute, should not have any connection with the either party, should not have had preconceived notion about this due to any reason. Once they are proved that, then they will go for the arbitral tribunal will be formed and hearing and adjudication will go on. Hearing will go on. Compared to court, this will be shorter. Relatively cheaper, relatively shorter. Why I say relatively? If you are expecting some quickly, you go there, check. No. The arbitration also will take about 1 or 2 years. As like 1 or 1.5 years, depending on how you do it. Suppose you are giving all the documents, you are giving, both are coming quickly, they want a resolution, go on. Okay, and if it does not, arbitral tribunals have the power to pass ex parte also based on the evidence that they have. Ex parte does not mean without the other party. No, it means at the request of one party, ex parte, at the request of one party, arising from one party. Means one party is coming regularly, filing all the papers, and then he's saying, hey, come on, you call him, he's not coming, not producing evidence, simply wasting it. But generally, arbitral tribunals will not pass orders in those cases. Why? Because of what Janvi is saying. Immediately what you will say, arbitral tribunal is biased, they did not give me time like that. You are given 7 times. You didn't come. You didn't file one bit of paper to counter what is it. Simply your lawyer is coming, telling we need time, or else some bullshit argument is giving and running away. But still, arbitral tribunal cannot do anything. This is, see, the same problem of court here also. Because if at all they pass an award, immediately the other party will rush and say, I was not given sufficient opportunity. Or there was a bias in favor of the other party. Like what? So that is why they rarely, court also will be very careful. If it is clear case of not giving any support and simply then coming and saying no, they will dismiss it straight away. Okay, that won't stand. See, many times, clients come to me with 144 orders before the assessing officer would have passed a 144 under the Income Tax Act. So he's shocked and surprised. Boss, gave you one hearing, you could have filed the details, second hearing, third hearing. Third hearing, you should have rounded up everything, completely filed. Then arguments, in the sense, on issues there where is a dispute, only we need to be talking. Everything other than, see, he's asking something to be reconciled. You have reconciled, check, over. Check, all tick. Finally, 2 matters remaining. I'm not happy. Talk about it. Then you say this is what is. Produce the case law. Third hearing would be at that stage. I've found many cases where third hearing also you're not filing all the details. What are you doing? And then he gets frustrated. He gets time barred. Then what he does? He gives you one more final opportunity. When I say you, I mean the party. They filed some bullshit reply there. I use the word bullshit very, very carefully. No connection with what he is asking. You had so much opportunity. That opportunity is not fully taken. Then he says no, and he passes the 144 order based on the material available on the record. Material available on the record. He is not passing it with considering any of the arguments. Whatever is there on the record, the duty of the quasi-judicial authority or the arbitral tribunal in ex parte awards becomes very, very difficult because you have not argued. On your behalf, I have to argue now. He has argued all the things. On your behalf, I have to sit in judgment. That is almost like the Sengol, that the speaker in the House of Parliament has to have. That is why it's called Sengol. It should be straight. It should be 90 degrees straight. It should not go like this, not go like this. Okay, that is Sengol. That's why it's called Sengol. It is a stick made of gold. Okay. And it should be held like this usually it will be held like this. Exactly. Okay. It's called a setter. SCEPTR, setter. It is not a sign of royalty. It is a sign of justice and righteousness. And it should be straight. Okay. So that is how arbitral tribunal should be there. So the arbitral award is finally given, binding on both the parties. No appeal. Okay. If you don't like it, I cannot do anything about it, but no appeal. Because keep on appealing, keep on going. Okay. That is how it is. My guru, Professor K. Santraman, used to say, law is made at the cost of the litigants. I repeat, law is made at the cost of the litigants. See, one litigant goes on appeal, spends money, gets an order. Now, Gujarat High Court order is obtained. Good. Now the Gujarat High Court order is becoming somewhat binding. But what happens? The Income Tax Department goes on appeal to the Supreme Court. Supreme Court passes an order in favor of the assessee. Now that becomes binding on all of us. So who spent for it? This poor Bakra went all the way up to Supreme Court, got an order. Now all of us who are in the same situation, our cases are all pending before tribunal, High Court and all. We are all waiting. All trains are shunted and waiting for the Supreme Court decision to come. Chuck, that Supreme Court decision comes favorable to the assessee. Wow, that's all. All these cases will get decided. Just because that Supreme Court decision is now res judicata. Res judicata. No more dispute. Because on the same facts, already one decision has been given by a court. Another matter cannot be taken up on the same facts. You cannot litigate. That's called res judicata. So, like that. I'm just, since we are in a slightly legal topic, I'm sharing some thoughts. I hope that's okay. I'm not seeing any comment after that. I think you all got bored and ran away or something. I'm sorry about that. But law is a very interesting subject, yes or no? Do you agree? Law is an interesting subject. Okay. As a chartered accountant, you are not expected to be an expert in law, but you should have enough knowledge in law to be able to hold a good conversation with an advocate. The advocate should feel, hey, you know a lot of law, man. Like that, he should say, you know a lot of law. You know the legal procedures. That is how we should prove ourselves as chartered accountants. Everything we should know a little bit. So when you talk to the other gentleman, you say, hey, you know the subject. Okay. That is how we become experts and authorities and professionals to whom others will come and they will ask for, advice. Okay. Chalo. So, arbitration agreement, consensus item, arbitrator is selected by the parties, seat of arbitration, that is location, is selected by the parties, party autonomy is there, there's a lot of flexibility, award is binding on both parties, no appeal, easy enforcement, especially in international arbitration, they can simply come file a decree. And the hearings are in camera. In camera means, don't confuse, camera is a Latin term here, which means without public being present. In camera means private. In camera means in private, as against public cases. So you go to the magistrate court. Believe me, next time I want you to do, after your exams are all over, just go to the magistrate court. You'll see. It will all be in public. Once for a traffic offense, I was asked to, FIR was filed. For some reason, I had to myself file for insurance. So it was a slight problem. So it was a bit of there was a dash between, when I was very young, like 28 years old at that time. So nowadays I don't drive. Okay. For the last 15 years, I've never driven a car. I've been told not to drive. My driver drives it, and my wife has told very clearly, no driving. Because when I drive, I keep thinking about matters and all. So I said, no, you are I got a license and all, don't worry. I can show you my license. And I do drive well. Incidentally, when I do get a chance to drive on the highways and all, I do drive well, but I've been prohibited from driving by my wife. No, only chauffeur drives. So at that time, I had a mild thing. So I had to go to court, and I stood before the court, and of course, I had gone straight, and that other fellow had come from somewhere and hit me. He had come fast. I was going slow. But because I am the affected party, I have to get out of this now. So my lawyer told me, don't talk. Whatever I say, tell. So you plead guilty. Say, agree. Then only the case will be get. You will pay 200 rupees fine. So I stood before the judge in public. Think about it. Everybody is watching. Okay, don't worry. It's only a traffic offense. Nothing will happen to my membership to the institute for a traffic offense and all. They can't debar me from practice. So when there was no other go, you had to go there, stand. So he said, the judge will ask you anything. You don't say anything. Say yes. Say yes. Okay. So the judge said, okay, what is this case? Okay. Are you pleading guilty? Yes. Fine is that 200 rupees. Pay immediately. Yes, sir. Yes, Your Honor. Oh, that's all. I can't talk. I told the advocate, boss, plead not guilty, man. I will argue. Hey, he said, this is not cinema, sir. You start, if you plead not guilty, straight away, you will be prepared to come to this court every week 2 times. For the next 3 years, are you ready to come? We will start the case. Not guilty. Hearing will be there, witness will be there, everything will be there. Criminal case. Are you willing to come? Come. Otherwise, pay $200 and go. Okay. So, why I'm saying it's in public. And imagine my shame, this budding child, I'm going to go there, stand in front of everybody, all pickpocket, pimp, prostitute, everybody standing there looking at me, who is this fellow like that? Then I go, 200 rupees, I pay the fine and I come. Okay. So, what to do? It happens. That is in public. Whereas arbitration hearings happen in camera, in private. Okay. In the private chambers. Sometimes in the private chambers usually in camera. See, sometimes when certain matters are to be discussed, which public should not know, the judge will call for an in-camera discussion. Only the advocates and the parties will be there, but that will be very rare. Then the judge also will decide when it stops. And it say no. And come out. No, what you did is wrong. You correct it. You wouldn't want to reprimand the advocate in public. So I would call him into this chamber and he'll give him the warning and then say, next time I see you doing this, that's it. And then go back and now you start the argument again. That will be again in public. I don't know. Any of you from Kerala or any other state near Kerala like Tamil Nadu or Karnataka who saw Mukundan Unni Associates, you will understand what I'm telling. Mukundan Unni Associates, I think that was a movie. You'll understand what I'm telling. That is called in camera. Thank you, everyone. Thank you. So now quickly litigation and arbitration I'm not going to cover it in depth, but you already know so much, so I don't want to waste your time. It happens in court, it is chosen by the parties, judges assigned by the court, arbitrators are selected by the parties. Procedure is fixed by the CPC, Code of Civil Procedure, whereas here, to an extent, the parties can decide how they will do it. To an extent, I'm being very, very careful. Usually, the arbitration council, that arbitration institution has its own rule book. You will not abide by that, but that will be flexible. See, CPC says 15 days and all. Here you can say, sir, don't say 15 days, give me 30 days, alone. They can change, like that flexibility is there. Procedures and rules are applicable, whereas here you can adopt your own. And there is an arbitral institution, and they will have their own procedure. Each arbitral institution will have its own procedure, but generally they will follow the UNCITRAL model, which is very flexible. Proceedings are open to public. There is very little privacy. Whereas confidentiality is one of the most important characteristics, which is why corporates prefer arbitration. Because many matters that are being discussed are corporate, they are very delicate corporate matters. If the press comes to know about it, it will be a different problem. So, suppose there's a big arbitration award wherein this company might have to settle huge compensation. Now, if that comes to the press, before they make a press meeting and announcement, it could be wrongly presented to the people. Therefore, after this is over, once they have agreed, they'll be going out and then they will call for a press meet. When the legal team and the, they will all sit and they will give a press meet and say, this is what happened. We have agreed to pay. As a matter of gesture we are doing, they will give their own spin. That is possible, but public, no. The minute the court passes the order, that's it. All the reporters will run out. Okay? Tobacco Limited has to pay 200 crores damages. Immediate headline. Immediately you will all get it in your news channels and everybody will know about it. Next thing, Tobacco Limited share will go down. And for no reason it will go down. Because nobody will realize that even after this award is paid, Tobacco Limited still has 3,000 crore worth of assets. Okay? Still it will go down. Court decisions are subject to numerous appeals. I already talked about this. It is often difficult to enforce judgment of court. Here it straight away, if you have no dispute, you cannot delay, you have to pay. Okay. Now, arbitration agreement means an agreement referred to in section 7. It is an agreement by the parties to submit to arbitration all or certain disputes. Disputes may have arisen or may arise, meaning today we have no fight, but we say in case it arises, disputes which may arise, we will subject it to. Or if it is already a past, already the dispute has arisen, now they can agree to give it. The dispute is in respect of a defined legal relationship. The relationship may be contractual or not. Again, I'm telling you, an obligation to pay money may arise out of a contract, or it may arise out of some action by one party, which it's called a tort, where I have done something which causes damage to you. Then I have to compensate you. Now, so I have a duty to compensate. No question about that. How much is the compensation? That is the dispute. That can be subject to arbitration. The fact that I owe you money does not arise out of contract. It arises out of my conduct, shall we say. I have done something that affects you financially. So you are demanding that I should compensate you. See, you are my neighbor. I was backing my car. I dashed against your compound wall and broke it. Period. That's it. I owe you compensation. No, why me? My neighbor did it to me. She was constructing her house and did all sorts of damage to my side wall. And I kept on going and telling her, madam, you have to do it. I will compensate you. I will compensate you. Finally, she went to Canada. And then when she was in Canada, I said, madam, how are you going to compensate? No, I will compensate you. Don't. I said, yeah, I know you will compensate me. When are you going to compensate me? How much are you going to give? Are you going to repair it yourself, or shall I repair and send you the bill? No. I will compensate you. Okay. See, that is the problem. So that liability is there, but amount is not agreed. So there we got arbitration and say, look here. This is amount, this is some civil construction cost, this is amount, brick, cement, which bill is there. I think maybe give or take 10%, 20%, pay me, go. Simple, matter over. Okay. The relationship may be contractual or not. The arbitration agreement may be in the form of an arbitration clause. See, at the time when you enter into a contract with the other party, in that contract, there could be an arbitration clause. Meaning, we'll see the clause. It's a standard wording that you put. Okay, future. Forget the exams. You will all pass the exam, etc., etc. Now, so you will don't worry. Later, if at all in any situation you are drafting an agreement, any agreement, lease agreement or contract or contract for supply of goods, whatever you're drafting or vetting, ensure that there is an arbitration clause. Please put an arbitration clause there, so that any dispute arising in that, they already have an option to go for arbitration. They need not get into a separate agreement in the form of a separate agreement. Put it there. This is something basic legal drafting skill I have taught you now. If you are asked to look at an agreement, vet it, and you comment on it, please put this comment clearly there. There could be an arbitration clause. Please insert an arbitration clause. Okay. The words of the arbitration clause, we'll see it. Arbitration agreement shall be in writing, but it need not be a formal agreement. It could just be it need not be in stamp paper. It could be a document signed by the parties, or an exchange of letters, telegrams, or even email. For example, there is a dispute. Then we send them a mail saying we have already supplied goods in April, for which amount is due in 60 days. If we find that it has fallen due, but we are yet to receive why. Then he sends a mail saying, as you are well aware, we have already been finding out. Our quality team has been giving reports. Then you go back to your quality team. They say, Then you come back, take the paper, and say, okay, whatever it is, according to our team, this is the only defect. You have to pay us balance. Some dispute has come. So all this mail is there. Finally, they say, the other party says, as this matter is becoming a little complicated, we suggest that it may be referred to arbitration. Though there is because to begin with, there was no original contract. You supplied goods based on purchase order. Note it, the purchase order is part of the purchase order the purchase order sent by them is an offer. You accepted it. Please note it. They will insist. Once the purchase order comes, they'll send it in duplicate. They'll say, please acknowledge receipt and confirm that you are in agreement with the terms and conditions. So you will sign it and send it back. That signed purchase order is actually a contract, but unfortunately, it does not contain arbitration clause. Some people will smartly put an arbitration clause even in the purchase order. Or they might put it in the invoice. Depends. Wherever you want to put. If you don't put it, then finally, based on the PO you have supplied, DC is there, everything bill, you have raised the invoice, and finally now they are doing like this. So you will now enter into an agreement. So when there is an existing dispute for which exchange of letters is there, you want to go for arbitration, you can have an agreement. Also, a dispute has already started, even it has gone to court. Now you want to come back and amicably settle it on arbitration. Court is more than happy. So you go to them and submit an agreement. You say, now we have entered into this agreement. We want to test arbitration. Kindly permit us. So the court will say, please go. If you think it is possible, go. Finish it, come. But invariably what they'll do, they'll go through arbitration. Finally, one fellow will come on 32. Again, he'll come here and stand. Sorry, that is not right. Okay. Then the court has to decide that matter now. Okay. So, if even a exchange of statements of claim and defense in which the existence of the agreement is alleged and not denied by the other, please understand. We are saying, as you are aware, we already have an agreement for arbitration, and by virtue of which we have agreed to refer it to arbitration. We suggest that you go ahead with it. The other party, what you should say, what agreement? When? No. If he does not deny, not denied, that's all. That this series of correspondence will become arbitration agreement. Arbitration agreement. Look at this. C owns a shop in Chandni Chowk dealing in ready-made clothes. D is a supplier of clothes to C. They have been doing business for many years. For each consignment, D issues an individual notice invoice to C on the basis of which payment is made. Each invoice contains the following note. All disputes pertaining to this transaction, if any, will be subject to the arbitration rules and regulation of Bharat Merchant Chamber. Okay. So, D, that's what I said now. In the invoice itself, they will put arbitration clause. So, what this C has put, D has put in his invoice. Okay. All disputes pertaining to this transaction, if any, will be subject to the arbitration rules and regulations of Bharat Merchant Chamber. Many chambers of commerce have arbitration councils. They act as arbitrators. They give a panel and they are encouragers. So this is a valid, because they are very clearly stated now. The Bharat Merchant Chamber has arbitration rules and regulations. There everything will be given. Based on that, you will proceed. Valid arbitration agreement. In case of an arbitration clause, it should be in writing, and the arbitration clause forms part of the contract. This is a sample. Later on, when I share this with you, you can use it also. Any dispute or difference whatsoever arising between the parties out of or relating to the construction, meaning, scope, operation, or effect of this contract, or the validity of the breach thereof, shall be settled by arbitration in accordance with the Arbitration Conciliation Act 1966, and the award made in pursuance thereof shall be binding on the parties. You can make this comment. Okay? It can be included. Or you can say, in accordance with the regulations of so-and-so arbitration council also. In 2019, Company A, an automobile manufacturer, entered into an agreement with Company B, the largest manufacturer of tires, for supply of all-terrain tires for its latest car. Both the companies are registered under the Companies Act 2013. Okay. Now the agreement has the following clause: all disputes shall be arbitrated in Mumbai. It is contained in the principal contract, there is a JVA. No disputes have arisen, but it concerns future disputes. So this would be a valid arbitration clause. All disputes shall be arbitrated in Mumbai. But see, this clause is very, very bald. I am not in favor of this, but it is not invalid. It is all disputes shall be arbitrated in Mumbai. Compare this with this sample. The elaborateness of this. There is a point. The JVA does not have any clause relating to arbitration at all. Disputes arose. Already they have arisen, okay, concerning quality of tires. In order to resolve these disputes, parties enter into an agreement to submit all disputes, including those related to quality of tires. This is called an agreement submission agreement. There was nothing in the original agreement. Now we are having an agreement. So these are the requirements. We already saw this. Consensus item, clarity of intent, neutrality, award to be final and binding, ouster of jurisdiction. That is, you should clearly say, High Court will not have jurisdiction once the matter goes to arbitration. Once matter goes to arbitration, no High Court, no court, nothing. You go through arbitration. You agreed. It's a breach of agreement. Consensus item. Okay. There should be principle of separability. See, even if the original agreement is invalid, suppose the arbitration clause can be separated and executed, then you can have it. You can apply the arbitration clause, even though the original agreement may be seen as invalid. And the dispute should be something that should be capable of being arbitrated. There are disputes that cannot be arbitrated. We'll see that. A and B enter into a contract for supply of goods, which states that disputes may be referred to arbitration if the parties mutually agree. This is not an arbitration agreement. You should say disputes will be arbitrated by so-and-so, so-and-so. Clarity should be there. If you mutually agree, means at that time you will agree. Then only arbitration agreement. This clause is not an arbitration agreement. The purchase order noted that the terms and conditions, see, that's what I said. Sometimes in the purchase order also you can put arbitration clause. Nothing wrong. See, these are all commercial documents. They are, see, contract does not necessarily have to be in one format. Anyway, so the purchase order itself is an offer, acceptance, contract. So purchase order can contain an arbitration clause. But here they say the arbitration will be as per the terms and conditions of the Fertilizer Association of India. Nothing wrong, because such association is there, and it has clause 15 provides for settlement of disputes by arbitration. Valid. So these are arbitrability, disputes that may be referred, disputes in relation to property, breach of contract, partnership, disputes between franchisor, franchisee, disputes between co-partners of a property, family disputes between brothers regarding to property, assets, how the business will be run, family disputes. Be careful. Matrimonial matters, no. Matrimonial matters not subject to arbitration. Okay? Because that's a more delicate matter. That's criminal proceedings. No. Means Mr. A cannot shoot the son of B or run the car over the son of B and then quietly say, let's have arbitration to decide how much compensation I have to pay you. No, sir. What you have done is a criminal act against society. I'm sure you've heard of many cine actors in a drunken state, they run over the payment, people who dwell on the payments. Okay. So they may try to buy off these people. No. Justice is there. What you have done is take a life for a life. In Tamil Nadu, we have a king called Manu Nidhi Chodan. He followed the same law strictly as Manu followed. That much fair. His son went over a calf. The cow came and, reported and asked for justice. And Manu Nidhi Chodan, he said, your child was killed by my child. Kill my child. He killed his son by going over him under the chariot wheel. He ran the chariot over his own son. There's a famous story of justice in Tamil Nadu. Manu Nidhi Chodan. That is Sengol. That is the Sengol that we are talking about. That is the Sengol, where he decided, even if it's a cow, the same offense, what your child was killed, my child will be killed. Who killed my child? My child will be killed. He killed him. That is a criminal proceeding. No arbitration. Justice and justice only should prevail. Okay. Of course, in addition to that, compensation may become payable. That is different. But you cannot negotiate and say, hey, drop your proceedings, I'll pay you money. No. Proceedings once filed, even the person who filed cannot take it back. FIR is final means even you cannot come and say, incidentally, I'm doing. No, cannot do that. Of course, what the rich people do, they will weaken the case. The same fellow who gave the complaint will come back and say, I don't remember, like that. No, he will say. Okay, that is a different story. But whatever it is, cannot be withdrawn. Matter will go on. Insolvency proceedings. Okay, no. That is coming only under the insolvency court. You have to go there, insolvency court, or you have to go to the insolvency, what is that? IBC, insolvency board. Contesting the validity of a will. No, arbitrator cannot, because it's too complicated and it involves ownership. So definitely it has to go to court. So mutual consent. Actually, just give me another 5 minutes. I'll give a quick break. But today it has to be a little, because I seem to have talked a lot on unnecessary topics. So we need to cover, but it's okay. We'll quickly cover it. As in the case of any other contract, the parties involved can jointly agree to put an end to a particular arbitration agreement. They can also say, in the middle of the arbitration, they can say, it's not working for us, stop. We are stopping with the arbitration at this stage, cancelling it, go back to court. Whatever you all, go to court. So arbitration agreement always operates in relation to a principal contract. If the principal contract is terminated through discharge or novation, the arbitration agreement terminates. However, if the principal contract is breached, then the arbitration agreement survives because of the doctrine of separability. See, he agreed to pay, he didn't pay. There's a breach now. Merely because it is breached, you cannot say the arbitration agreement is failed. No. But if the parties themselves have either discharged the contract or novated it and created a new contract between themselves, then the old contract is novated. That old contract, if it has an arbitration clause, that is also gone. Okay. See, in fact, suppose there is an old contract with an arbitration clause. Through mediation, you come out with a new novation. In the new, there may be an arbitration clause, but the old arbitration clause is gone. The agreement is gone. I hope this part of separability is clear. When there is a breach, the dispute is going to be on the breach. So that fellow cannot question the agreement, and he is questioning the agreement, no doubt, but he cannot question the arbitration clause because the arbitration clause is separable. It has no connection to the main body. In case there is a dispute in the main body of the agreement, the arbitration clause will come into play and you will have to refer it to arbitration. Then the arbitrator will decide on the main body of the breached contract as to who is right, who is wrong, and all. Death of party. Under Indian law, an arbitration is not discharged, but see, contract does not get discharged by death of party. Only one type of contract will get discharged by death of party. You know that from your foundation itself. That is contract of personal skill, contract involving personal skill is discharged by death. Obviously, you wanted Usha, what is that? Usha Utu or Asha Bonesley to come and sing. Asha Bonesley has to come, yeah. Her daughter cannot come. Okay, so nobody can represent her. Okay, suppose the contract is cancelled, which contain arbitration clause. So where arbitration done for claim? What do you mean by cancelled? The word cancelled is a loosely worded. What is cancelled? You mean breach? If it is cancelled, is it substituted by another contract? If you are using the word cancelled in the same meaning as discharged, that contract is no more. They maybe got a new contract. Then the arbitration clause also fails. Unfortunately, you have used the word called cancelled, for which there is no legal clarity. Would you like to give that? What do you mean by cancelled? Arbitration can be done for claim or issue. Who cancelled it? Unilaterally, if one party cancels it, it is breach. Mutually, if they cancel it, then what is it that happened there? Did they discharge it? Did they agree to treat it as not relevant anymore? Then arbitration clause will go off. Did they replace it with a new contract? Then the new contract will take over. This will go. So, if you mean by cancelled, you mean discharge or novation, then this will apply. But if you mean cancelled by one party, then that is breach. You enter into an agreement, you can't cancel it. So when I'm also a party, so it's a breach. In which case, arbitration agreement can be enforced. See, some of your questions are so vague, I have to give double answers for it. What to do? Huh? Janviji, are you clear? So an arbitration agreement can be extinguished by the operation of law sometimes. Okay. Smart Automobiles Limited and Apex Four-Wheelers Limited entered into an agreement regarding AIM's annual maintenance services to be provided for smart automobiles for all vehicles within the state of Uttar Pradesh for 5 years. The agreement was containing a clause that in the event of a dispute between the parties, the matter would be submitted to arbitration. At the end of the 5th year, the service agreement was not renewed. Decide whether the arbitration agreement should not be treated as terminated. Also describe the other grounds of termination of an arbitration agreement. Think about it. What has happened here? There was a AMC agreement. Okay, it contained a clause that disputes would be. At the end of the 5th year, it was not renewed. That means what? Now this comes to your example, Janviji. This is your example. The contract is cancelled. With that, the arbitration clause also dies. It is to be treated as, the arbitration agreement should be treated as terminated. Okay. Here, I think if this is what you mean, then the answer is it should be terminated. But suppose during the pendency of the agreement, during that 5 years, there was some dispute arising. That can still be settled under this clause because for 5 years it was valid. You can take it up, provided the breach happened during the 5 years. When the original agreement was valid, then the arbitration was valid. But when the original agreement got terminated or not renewed, automatically the arbitration agreement also gone. So the arbitrators or arbitral tribunal performs the function of a judge. The terms arbitrator, arbitral tribunal are interchangeable, refers to the same person. Therefore, there could be one or sole or more than one. Both would be referred to as arbitral tribunal. One man is called tribunal. A unique feature of arbitration, unlike court-based adjudication, is that parties get to select their arbitrators, or they can even ask somebody to appoint, including the ICAI. The Institute of Chartered Accountants of India could be directed to appoint 3 chartered accountants to select from their panel or senior chartered accountants. ICAI can select and say these are the arbitrators. Like they can leave it to an institution. Qualifications: competence to contract, independence, expertise, neutrality, competence. The competence to contract is different. Age of majority, not of unsound mind and all. Here, this is competence in arbitration and knowledge of arbitral process. Okay. Almost similar to what a member of the institute is required, na? Except the last line, which is knowledge of arbitral process, which you are now learning. So all of you are now ready to become, once you become member of the institute, automatically you can become arbitrator. Many arbitral councils, they take applications from CS and they provisionally admit them as arbitrators, but they expect them to attend an orientation program. And maybe they will ask them to show some experience in at least 1 or 2 arbitrations. Then they will recognize them as full-fledged panel members. Till then, they'll put them on provisional panel. But they'll still be in the panel, but they'll have to show some proficiency. Circumstances which preclude neutrality. Arbitrator is an employee, however high qualified. An employee is always not independent. A consultant, no. An advisor. See, this connection is there now, all said and done. Okay. Arbitrator currently represents the lawyer or law firm acting as counsel for one of the parties. Arbitrate, this is where I got disqualified. Do you remember my story? Arbitrator has given legal advice or provided an expert opinion on the dispute to a party, which is what I have done. I gave an expert forensic opinion on that one party had committed a fraud, which was accepted by the court. But then they decided to come to arbitration. Even in the arbitration proceeding, my report was used. That same lawyer came back to me and said, give me some more data. And they made me go in depth into the vouchers and give more detailed report. I gave. Based on that, finally, the arbitration was in favor of the party to whom I gave the opinion. He got the benefit. Finally. Arbitrator is a legal representative of an entity that is party in the arbitration. Or arbitrator has a significant financial interest in one of the parties. Even one share, no. Be very, very careful. Check out your portfolio. If you are going to be arbitrating a matter where ABC Limited is coming, if you are holding shares in ABC Limited, God. See, though the word significant is used, no, even one share, yeah, you are interested like that. Arbitrator has previous involvement in the case. If there are 2 arbitrators, so number of arbitrators, friends, I'm going to seek your kind indulgence today. Okay, why kind indulgence? I will have a small break. Now time now is about 7:50. 5 minutes for biology. So a small break, sir. Welcome back from a very short break. I know when I'm not able to have a cup of tea, just could go to the wash and come back. Anyway, so if you're having a tea, just bring it to wherever you are and enjoy the cup of tea while listening about arbitration. So now we are going to talk about the mechanics of arbitration, how the arbitration actually goes on. So we have number of arbitrators, all that stuff. So be careful because this is most crucial. 10 is most crucial. How you select the arbitrator. Okay, be careful. Ideally, you should have an odd number of arbitrators. Ideally odd, not odd arbitrators, odd number of arbitrators. Okay, because the word odd, in English has two meanings. Odd means strange. ODD, odd means strange. He's an odd person, means strange behavior, like that. But odd also means numbers which are not even. Even means numbers which are not odd. So basically, 1, 3, 7, 9, and all are odd. Okay. The numbers that are divisible by 2 are called even. Numbers which are divisible by 2, even. Numbers which are not even or odd. That's easier, no? Numbers which are divisible by 2 are even. So 2, 4, 6, 8, so on. Then numbers which are not even, 1, 3, okay, like that. Because some of the odd numbers are prime numbers also. Some odd, except 2 is the only prime number. Even 2 is not, 2 is a prime number. There is its prime number means divisible only by itself and 1. Itself and 1. It's called a prime number. So that we have all odd numbers, you'll find prime numbers are also there. Okay. Whereas even numbers, you'll never find prime numbers. So, because they'll be divisible by 2 now, 1 itself and 2 and some other number always. Okay. So 4 will be 2 and 2, 2 and 1 and itself. Okay. So odd numbers, I think. If there are 2 arbitrators, then it is possible that the 2 arbitrators may not agree, in which case there would be no decision, there would be a tie. So the parties are free to determine the number of arbitrators provided that such number shall not be an even number. See, the reason for even number is tie, that they may not come to an agreement. Instead of having dispute between the parties, there will be dispute between the arbitrators. Who will dispute? Who will settle the dispute between the arbitrators? So, better it has only 1 or 3 or 5 or 7, 9, so on. Does it mean that you cannot have even number at all? No. Not like that. A and B enter into a contract containing an arbitration clause providing for 2 arbitrators. Look here, at the time when they entered into the contract, these fellows put 2 arbitrators. No. So the A and B both were aware that there are only 2 arbitrators at the time of signing with open eyes. Okay. Later there was a dispute arising on the contract which was referred to an arbitral tribunal consisting of Mr. M and Mr. N. After hearing the dispute, the arbitrators unanimously passed an award in favor of B. Both the arbitrators in favor of B. Now A objects to the award. Now they say there's a bias basis. Now only you will realize at that time what was happening. Okay. Now A objects to the award on the ground of even number of arbitrators. Can he do so? See, strictly speaking, the Arbitration Act says should not be even number. Section 10 says shall not be even number. But doesn't mean, say, your agreement had 2 bars, right? And these 2 arbitrators, poor fellows, they came, they heard, and they finally passed an order in favor of B. What was A doing throughout the arbitration? Throughout the arbitral proceedings, A had the opportunity. Now, why didn't you object? Why didn't you at least register an objection which was overruled? Then also you are safe. You did nothing. It's the arbitral award has come, which is against you. Now you go to the court and say, it's sorry, no. And why is, and there the Supreme Court asks, why should there not be even? See, if there could be a tie. But here is not a case where both have agreed. Even number of arbitrators is an acceptable possibility. It is not an impossibility. It is not as if two arbitrators can never agree. They may not disagree, as in this case. They may agree, okay, in this case. So it is quite possible, okay, that they can do this. In fact, the parties may agree that the arbitrator is not useful. That alone they may agree. A person of any nationality may be an arbitrator. This is part of UNCITRAL model. This is so unless everywhere in the Arbitration Act, from now on, there will be one not Taraka Mantram, one Charanam and Pallavi. Again and again we'll sing this now, the refrain. It is called, in English, it's called refrain. That two lines which will be sung again and again. Like that, this will be sung again and again. Unless otherwise agreed by the parties, unless otherwise. So any statement is unless otherwise agreed by the parties. You will find many such cases where unless otherwise agreed by the parties. So if the parties say only Indian, then only Indian. But if the parties are silent, then any nationality. So always remember, unless otherwise agreed by the parties. So anybody can. Why? Because see, today, international arbitration is a big business. Telling you. You just go to Singapore and attend a certification course. But Singapore was, okay, that's also not enough, I'll tell you. Many people think if they spend some 10 lakhs or 15 lakhs and some advocates themselves think, the young boys, they think if they go to Singapore and study in Singapore University, arbitration, specializing in arbitration, Mr. Srikanth, like that, chalo yaar go. Experience, where? Okay, you come back to India and say Singapore, sit down. What did you do in Singapore? Okay, that is the reality. Sorry to be so blunt, but that is a fact of it. But again and again, I'm telling you, our membership is the most valuable thing that will ever happen to you. The most valuable thing in your life is going to be that paper, that document, that important life-changing event when you will become a member of the Institute of Chartered Accountants of India. Look forward to that day, work towards it. Other certifications, everything is compared to this one. Membership, please. So, in the absence of any such agreement regarding the procedure, and in an arbitration with 3 arbitrators, the procedure will be as follows. That is, unless otherwise agreed with the parties, where there are 3 arbitrators. Are you able to see why this is called refrain? Okay. I think in Tamil, in Carnatic music, we call it Charanam. Means again and again we sing it. So I may be wrong. If you are an expert in Carnatic music, any of you, I'm sorry. Okay, I'm not an expert. Okay, though my son sort of claims to be a Rasika. He's a connoisseur of Carnatic music, but he also cannot sing. Okay. So if you are anybody here is, but refrain. In English, I can say refrain. It will be again and again, unless otherwise agreed between the parties. Where there are 3 arbitrators, each party shall appoint 1 arbitrator. The 2 appointed arbitrators shall appoint the 3rd arbitrator. So both will appoint 1 each. Anybody, my friend, your friend, whoever. So long as he should not, he should be independent. He should not have given any opinion on it. Independent man, my friend, bring, no problem. Independent man, my friend, bring, no problem. These 2 guys together know how to come to an agreement on 3rd. The 3rd will be the presiding arbitrator. Unless otherwise agreed by the parties, this is what it will be. Suppose they have prescribed some other method, then that will be a problem. For example, the rules of the Nani Palkiwala Arbitration Council, whatever is meant. It so happens they have, that Nani Palkiwala has the same rule. They have almost adopted the Arbitration Conciliation Act. Okay, sole arbitrator. Joint appointment means single arbitrator joint appointment. Very difficult. 1 man, both should agree. Usually one party writes to the other forwarding a list of names of potential arbitrators. Out of that, 1 name is selected. Then that individual will be the arbitrator. Instead of giving 1 and saying so and so only, 3 names, 5 names, select 1. I am suggesting, or you select, then you send 5. I will see if it's workable to me. This will keep on happening. If not, then the other party would propose new names to the first party. This would go on till both parties agree upon 1 name. Okay. One thing, this is common sense and practical. Yeah. There's nothing here. It's all sensible human beings from time immemorial have made laws that are sensible. Only some comedians and jokers and buffoons who are suddenly they have come, they don't have any legal common sense. Only they will create some laws which are funny laws that have no logic, nothing. They'll come and pass and go. Appointment of arbitrators. More than one arbitrator. We already saw that. Party 1, arbitrator 1. Then 1 and 2 together, presiding arbitrator. This applies when the appointment procedure has been agreed upon by the parties. The Chief Justice or any person or institution designated by him may take the necessary measure for securing the appointment. If a party fails to act as required under them, see, you are supposed to appoint one arbitrator, you don't appoint at all, then Chief Justice. Who is the Chief Justice? The boss of the judges. Think about it. In a high court, let us say there are 15, 20 judges. All the 20 judges will have one boss. He would be the Chief Justice. Chief Justice of the Madras High Court. Chief Justice of Supreme Court. That's it. Okay, very, very important position. Because he will select which judge will sit in which bench. Which case will be heard by which judge. Okay. If a party fails to act as required under that procedure, or the parties or the two appointed arbitrators fail to agree as expected of them under that procedure, a person, including an institution, fails to perform. For example, we have said the Madras Fertilizer Association will decide. They have not done it. Then what to do? Chief Justice has to come. The Chief Justice may act only on request by a party and only if the appointment procedure does not provide for other means of securing. See, sir, he has to appoint, he is not appointing. I have selected and given. Please help. Then only he should. The decision taken by the Chief Justice or the person or institution designated by him on the matter mentioned above is final. There's no need for wasting time. Okay, proceed. Chalo. Move on. Okay, age. Don't waste. In appointing an arbitrator, the Chief Justice or the person or institution designated by him shall have regard to any qualification required of the arbitrator by the requirement of. See, some cases qualification. Though the Act does not prescribe qualifications. Nowhere. The parties may prescribe. The agreement may prescribe. But law does not. The law does not. See, after you become member of the Institute of Chartered Accountants of India, you will meet clients, you will meet MDs who are school dropouts. They'll be brilliant. Education has nothing to do with brain. Merely because a man has got qualification doesn't mean he's intelligent. Merely because a man does not have qualification doesn't mean he's a fool. No. Never underestimate a man because he's uneducated. Rather talk to him. Then you see whether he's got the necessary. Because so many businessmen whom I have had the good fortune to advise and audit and help were school dropouts. Or maybe they completed a graduation, but that's it. They went on with their lives. They earned crores. That is not their qualification. They built huge businesses. They built brands. So without qualification, they don't do MBA from any institute. Okay, not IIM. No. They are there. So that way, I have no regard for qualifications. Though I am qualified and I do teach you and I ask you to become qualified. Don't get misled by qualifications, is all I'm saying. Don't think merely because a man is educated, he is intelligent. Don't think merely because a man is not educated, he is not intelligent. No. Examine him and then decide whether. I have seen so many highly educated triplets and all talking bullshit and nonsense. Whereas, as I told you, school dropouts talking logic and sense. Other considerations as are likely to secure the appointment of an independent and impartial arbitrator. Okay. A person who is approached to be appointed as an arbitrator shall disclose in writing any circumstances likely to give rise to justifiable doubts as to his independence. In my case, I did not even have to go into the writing phase because over the phone call itself, he said, hey, no. Because I have done the thing. So immediately I was out. Okay. But it is up to me to disclose. Suppose I had kept quiet. Oh, that's not correct. Of course, later on you would have come to know about it somewhere in the middle of the proceedings. They come. How do you know all these things? I only gave the report now like that. If I say, oh, why didn't you tell me at that time? It's like that. Okay. So By then I would be in the arbitral council. So what to do? I have to recuse myself, come out. Somebody else has to come. It's solved a lot of problem by at once saying I'm not. From the time of his appointment and throughout the arbitral proceedings, the arbitrator shall without any delay disclose to the parties in writing any circumstance referred to. The arbitrator may be challenged on the following grounds only. Circumstances which give rise to justifiable doubts as to his independence or impartiality. You have to give the challenge immediately. You can't keep quiet and then challenge later. Maybe you didn't come to know about it. That will come to point later. See, at the time when his name was proposed, you didn't know that there was justifiable doubts. No problem. When you come to know, you have to take it up. Immediately you have to come. You can't keep quiet and you can't say later on I will do it. Okay? Suppose a party has appointed an arbitrator or participated in the appointment of an arbitrator. Now he may challenge the arbitrator only for reasons of which he became aware after the appointment was made. The time you have agreed now, then whatever you knew at that time, you are willing. Now you can't come and state that. Found something new, come. The parties are free to agree on the procedure for challenging an arbitrator. In the absence of any such agreement, the parties may challenge the arbitrator within 15 days after he becomes aware of the constitution of arbitral tribunal or becomes aware of the circumstances mentioned earlier. See, challenging an arbitrator is a very, very important part of this arbitral proceeding. If you feel that there is even the smallest iota of doubt, then in the agreement they might say, within such and such a time, within that time you have to agree. In the absence of any such agreement, within 15 days of becoming aware of the constitution or becoming aware of circumstances. See, when the arbitral tribunal was announced, 3 names were given. You have nothing, you know nothing about them. You thought all are good. Later you come to know that one of them is having some link there. Then you can come. Within 15 days you have to come. The challenge shall be made by sending a written statement of the reasons for the challenge to the arbitral tribunal. The arbitral tribunal shall decide on the challenge unless the challenged arbitrator withdraws. He himself says, yeah, I'm sorry, I didn't realize this, I'm sorry. That's decency. That is decency. Don't go there. The other party agrees to the challenge. Hey, yeah, sir, please don't. We'll get somebody else invested. That's all matter. The challenge fails, meaning the arbitral tribunal shall continue the proceedings and make an arbitral. Okay. There is a challenge. The court says, no, we'll continue. You have to go on. But that's not a good idea. I'm telling you again and again, don't, even if there's an iota of doubt, get out of it because this whole thing is opening up. We see what happens. You go to the court says, no, he is not biased. You proceed. So finally he passes an order. Then what happens? The party can apply to the court to set aside the award. That is all. There is no appeal. This is not appeal. This is an application set aside. Impartiality means what? Namrata ji. Suppose one of the parties to the arbitration is a company. You are the arbitrator, Namrata ji. You have to answer my question, then you will know what is impartiality. You are the one of the arbitrators selected panel. You are, let us say that you are a senior chartered accountant, you have a lot of experience, etc. We respect you. Now, you come. You are one of the parties to the dispute is a company wherein your husband's brother is working. Assume that you are married and your husband has a brother. Assume that brother is working in a very senior position in that company. Your brother-in-law is working in that company. Hey, brother-in-law is not a relative, no, don't tell. Here it's not Companies Act, this is Arbitration Act. Okay, there you hear no relative definition. So don't go there. Are you partial or impartial? Your husband's brother is a employee there, senior level employee. Are you partial or impartial? What do you think? Are you able to understand? There is some connection between the arbitrator and the litigant or the parties to the arbitration, which would impair their judgment. Not everybody can be Manunidhi Chodan, where we can stand with the Sengol and say, my son will be killed because he killed your son. That not everybody has the ability. Therefore, impartiality means wavering. Some circumstances that will make me biased. As Janvi was saying, biased. Meaning, preferring one party over another for reasons other than the case. Like that. Okay. That is why employee is impartial, cannot be impartial. Nah? Your salary is coming from that buggery. How you can say, no, I'm going to be impartial? It's not possible. Okay. Are you able to understand, Namrata, what is impartiality? Have you understood? Okay, impartiality similar to, actually, I wouldn't say independence and impartiality are one and the same. Please understand. An auditor may have a certain degree of partiality. After all, if you've been an auditor for 4 years, definitely you become close to that company. So, but still, you can be independent. But if your brother-in-law is there, you are impartial. No, madam. Okay, now come to the point. You will say you are impartial, but the world will not say. That it could become a challenge. Later on, they will say the arbitrator is a relative, is a executive in that company. Set aside. So don't go there. Never take a risk. You might say that brother-in-law and I, you don't get on very well. If he comes this side, I will go that side. That is not relative now. So there is definitely a suspicion that influence is there. Some influence is there. In fact, the great Chanda Kochar did exactly that. Na. She was sitting in the position of ICCC, and what she did, she gave a loan to a company where her husband is there. But clearly, where is you definitely support now? Where is the question of you are not Manani Chodan? Then you should not give that loan at all. Then only you are Manani Chodan. Don't even entertain such a loan, sir. Don't even go there. Where an award is made as aforesaid, the party challenging the arbitrator may apply to the court to set aside the award. That is very, very important. Even if you fight and you insist that this arbitrator should be there, quietly that fellow will sit, then he'll go for set aside. So don't even go there. And when the award is set aside, the court may decide whether the challenged arbitrator is entitled to any fee. Because all along you knew you should quietly discharge yourself and get it. Instead of that, you sit and do it, then no fee. So there are types of arbitral award. You have final award, interim award, settlement award, additional award. Interim award, I mentioned to you what it is. I gave you an example also. Final award, close. Settlement, where you give a settlement to the parties. Additional, by the name indicates, you already given an award. Now you say you forgot that this is also there. Additionally, we are giving this award. Okay. So arbitral award should be a decision by the majority. Meaning, if there are 3, 2 should be supporting. Must be made in writing, signed and dated and delivered. Must be reasoned. Must not be vague. Should be capable of being performed. Should not be illegal or against public policy. These are the arbitral awards. Sorry, I said 34. 32, it's 34. Yaad nahi hai. Slowly Buddha ho gaya. 34. Very, very, very important. 34, very, very important. Setting aside an arbitral award. But whenever we have, my son and I talk about arbitration, invariably we'll talk only about 34. Grounds when it can be set aside. Because as an advocate, he is only interested in that. Because he is more interested in seeing for opportunity where he can set aside and take it back to court. Because he is an advocate now. So he wants to set aside and take it back to court. So he will advise the client on set aside only. So most advocates will be expert in 34. 34 case laws, they'll be expert. Even you should be a little thorough in these grounds. The grounds when, see, an application may be made to the court for setting aside an arbitral award on the grounds mentioned below. Earlier, we had a question from John VG. What was that? An appeal cannot be filed against decision of arbitrator in case any of the parties is not satisfied or thinks conclusion is biased. No, it cannot be filed. No appeal. Only 34 application. On what? Saying that on the following one, you bring it under one of the grounds you go for an application, not an appeal, application to the court for setting aside the arbitral award. Okay, then if it is set aside, what happens? No, don't ask. If it is set aside, again start from the beginning. Go for another arbitrator, start. Or else go back to court, fall at their feet, please pass an order like that. Go to the old proceedings. That's all. Go back to court, enjoy. Okay. But invariably, in fact, I always say that no person who has won will never go on appeal. Person who has lost only will go on appeal. So invariably, the guy who is not getting what he wants, he will say that some problem was up. The party was under some incapacity, meaning what? He could not appear regularly because of some incapacity, health, whatever. Some reason you have to give and say, I could not come regularly. Like that. The arbitration agreement is not valid under the law to which the parties are subject. Now, this is something, that's what I'm saying, these are all technical grounds. How it's not valid under the law. So, in other words, you are not questioning the award. You are questioning the agreement itself. You are saying, and one more thing, important, arbitration agreement is a contract. Therefore, what happens? All the rules applicable to contract, the entire contract, Indian Contract Act 1872 applies to arbitration. So if you can challenge the contract, then you can challenge the arbitration agreement. If you're able to challenge the arbitration agreement and say it is not, then automatically the award is gone. So you go to the root. You cannot hit the fruit. You go to the root because you cannot touch the fruit. No appeal. The party making the application was not given proper notice of the appointment of an arbitrator. That is why notice should be given in registered post, speed post. Keep the proof. Most arbitrate. That is where operating through an arbitration council will help you a lot, because arbitrators are well advised to use a council and use that secretarial services because they know how to do it. So that tomorrow on this ground, they cannot go. Pakka notice will go. They'll give 15 days time to challenge, or whatever is given in the rules, they'll say you have 45 days time to challenge. Then they will send one more reminder saying you are not challenged. In case we don't hear from you on such and such a day hearing, we will assume that you are not having any challenge. Like that they will say. So if this procedure is not strictly followed, be a problem. Okay. See, many times, what I do in around May, generally, I think we already sent it, or in June we send it, where the Finance Act is passed, we send a mail to the client. Almost all about 500 or so. Small chotas over there, 300 chotas, other 100 mediums. And then we give all of them, we send a mail, giving clearly due date for filing or paying an advance tax, TDS, percentages, any change in the law for the Finance Act, any major changes, for example, don't accept cash, or this is not possible, that is not possible. Clearly in simple English we put, and we send it to all the clients on the road, not to other than client. No, only client who is on the client book, who is an existing client in the book, not some third parties. I don't send publicity materials, no. To my clients, why? And I say, if you have any doubt, come to me now. Why? Because, the fellow will be sitting quietly. Suddenly he will come and say, sir, you should have told me. You never told me. When did I not tell you? Please check your inbox. Mail is there. It is there. Did you read it? No, I thought it's a routine mail. Who told you to do that? I've sent an auditor, I sent you a mail. Should you not read it? Should you not understand what is said there? If you don't understand what I have told, if you want clarity, come, call me. I will explain. That is why you are paying me. No, sir. Sorry, sir. Made a mistake. That is better talking. Rather than saying, I should have told you, you should have told me. Don't make all this nonsense. Which means you should have meticulous documentation, meticulous correspondence, so that nobody can say, I didn't get. So three can be easily overcome by good secretarial support. This is not some rocket science. Okay. The party making the application was not given proper notice of the arbitral proceedings. See, hearing is there. Or in this hearing, these are the matter to be taken up. So again, document, give it. Why? Make him pakka aware of it. That is why, instead of send a mail, also send a registered post by speed post. so that you have proof of delivery. You cannot say, I didn't get it. Mail is also equally good nowadays, because mail, he cannot say, I didn't get it. Hey, on such and such a day, it's there, we opened it, see, what is this? The party making the application was unable to present this case due to valid reasons. For example, pandemic is a beautiful example. Zoom, maybe technology. See, you had your meeting on Google Meet, or you had your meeting on some other technological platform where the arbitrator said, we'll do it on Zoom or a virtual mode. Maybe the parties agreed. He also agreed. Subsequently, some problem, digital connectivity issue, whatever. So, unable to present. But in spite of that, matter got completed. So, believe me, these grounds are all very, only one ground, that is that fairness or impartiality, independence of that is where they can keep on going. The arbitration award deals with a dispute not contemplated by the terms of submission to arbitration. Means the arbitrators have gone beyond the brief, like that. Means we only asked him about quality. He is also talking about discount. I never asked him whether discount is to be given. That I will decide. You tell me what is the quality. For that quality, what is amount payable, we will decide. That we will negotiate and decide. But you tell us this is the quality. That's all. So you gone beyond that. Why are you wasting time? Like the arbitral, to that extent, it can be set aside. That's all. Please understand. Where they are agreed, to that extent, it will be set aside. Suppose in addition to that, he has said the company, the purchaser should pay the seller so and so after reducing 20%. Hey, who told you to say 20%? What is our arbitration about? Whether the quality is as specified here or not. You say it is specified. You say as specified or not specified. Then whether 20%, 10%, we decide. That is negotiation between us. Don't bother. You have gone beyond the terms of submission. Don't do that. The arbitral award contains decisions on matters beyond the scope of the submission. Terms, scope. Are you able to understand? Scope means what you are expected to do and what you are not expected to do. Okay? The limits going beyond that and telling scope of the submission of arbitration. Okay? For example, we told you to decide only on what will be the issue under this law, and you tell us, hey, you are telling me what is there under this point. Hey, nobody asked you. Only this. But again, be careful. The 6 and 7, what happens now? In case they have exceeded terms or scope, to the extent of them exceeding only, it will be set aside. The original award, to that extent that it is within the scope and terms, will be valid. If the decisions on matters submitted to arbitration can be separated from those not submitted, only that part of arbitral award containing decisions on matters not submitted may be set aside. Understand? What is separably submitted and separable can be. But if these are interlinked, then the whole thing will get. But rarely, if it is something that can be separable, then you can say, this part exceeds. No, this part, clear, do it. Separability is there. Finally, the composition of the arbitral tribunal was not in accordance with the agreement of the parties. This is where you can go again and again. Composition of the arbitral tribunal. The court may set aside an arbitral award on the following grounds also. The subject matter of the dispute is not capable of settlement by arbitration. I told you, certain matters cannot be arbitrated. The arbitral award is in conflict with public policy. Correct? So in those cases, very, very important. An application for setting aside may not be made after 3 months have elapsed from the date on which the applicant had received the arbitral award. Very important, 3 months. However, court may entertain an application within a further period of 30 days on sufficient cause being shown. 3 months. 3 months, 30 days. Okay. Consequence of challenge. It's either set aside, or they can confirm, or they can modify, or remit back to the arbitral tribunal, or they can finally say, no, we are enforcing it. Go ahead, do it. Do what they say. Where the time for application to set aside an award has expired, or when such application was made, but it was rejected, then the award can be enforced. The enforcement of an award, arbitral award, shall happen under the Code of Civil Procedure 1908 in the same manner as if it were a decree of the court. Decree of the court. Please note. See, decree of the court means you can attach. You can attach bank account. You can attach property, sell, take the money, whatever. We have finished arbitration. The extent relevant. 34 is very, very important. Now we move on to what is known as conciliation. Conciliation. Slightly different. It's not extreme, slightly. Okay. Arbitration, once there is an agreement, parties cannot say no. Once you have agreed to arbitration, you have to go to arbitration. You cannot say, no, at that time I agreed, no. Whereas conciliation is voluntary. 2. Generally, by the time arbitration has started, they are adversarial, they are enemies. Here it is not. It's an early stage, so non-adversarial. It is an assisted procedure. And here also there is a degree of confidentiality. Here also there is, thanks to the Arbitration Conciliation Act, there is a finality of settlement, but not as final as the award. Here also the number of conciliators depends upon the parties, but with a maximum of 3 conciliators. Maximum. Okay, 1 to 3. Whereas arbitrator, even 7, you can have odd number. Conciliator appointments are subject to party consent. Again, also you can ask an institution. Similar. See, that's where the similarity is there. This allows parties to approach institutions that provide professional conciliation services, such as ICADR. Okay. While making appointment, it must be ensured that the independent and impartial conciliators are selected. Same. When the conciliation proceedings are ongoing, parties cannot start arbitration proceedings or approach court. So, are you able to see the escalation? Negotiation fails, mediation fails, conciliation fails, then only arbitration or court. Okay. During conciliation, you cannot go to court. File a suit. Same dispute. If you do that, the other party will first reply itself will be, conciliation proceedings are going on, Your Honor. Oh, is it so? Why are you come here? Wait. They will say, till the conciliation proceedings get over, this is stayed. It's a matter of, you go back. Come back to us and tell us what happened, they will say. The exception to this rule is that when it concerns preserving its right, the party can approach a court for initiative. Be careful. That's what I said. See, suppose a conciliation is going on. In the meantime, one party is encroaching on the other party's rights in terms of possession, etc. Whatever. They can go to court and get an interim injunction. See, you cannot use conciliation as a cover for doing something. Okay. No. If such activities are being planned, then get it. Again, come back to status quo. That's all. See, the famous story of the farmer, who was going near the forest to cut woodcutter, was cutting wood. Suddenly he found there was a cage in which the tiger was there. The tiger was in a cage. It had been caught by the people, and the forest, the poachers had caught it. They were going to take it and sell it to a circus. So they had locked the cage and they had sort of not locked it. They had put the latch and they had gone. So tiger cannot come because tiger has no hand, it cannot open. So it's simply sitting there. Fellow comes. The tiger begs him, hey, please let me out. Yeah, somehow I won't harm you. Hey, you are a tiger. If I let you out, you'll eat me. No, I won't harm you. Immediately the guy was out of kind-heartedness. He lets the tiger out. Now the tiger immediately says, I will eat you. Just now you said if you come out, you won't eat me now. You have also become like human being or what? I don't care about all these things. I will eat you. So this guy says, let's go to 3 people and see what they say. So they go to the cow. Cow says, kill him. He used to milk me and, not feed me and all. Kill him. They go to the tree. Tree says, kill him. Fellow keeps on cutting us. Kill him. Tiger is now very happy. Now the third arbitrator. Clinching arbitrator. This is the problem. So the jackal is there. They go to the jackal. The jackal says, hey, let me understand. What is this cage you're talking about? Hey, the tiger gets angry. You don't understand cage, huh? It will be like this. Hey, you are such a big tiger, man. How you can go into such a small place? You idiot, you come with me like that. The tiger takes him to the cage. Then the jackal says, this cage, you were inside it? I can't believe it. So immediately the tiger says, I will show you. Then the tiger goes inside the cage. By then the farmer is smart. He puts the latch. Then the jackal says, look here, now there is a dispute. What is the dispute? If the tiger is let out by the farmer, woodcutter, if the tiger is let out by the woodcutter, can the tiger kill the woodcutter? This is a beautiful question. I will decide on it. Till such time, let status quo prevail. Till such time, where were you? You were in the cage. Where was he? Outside. Let it continue. We will decide this matter. Then we will decide what to do. This is called maintaining status quo. Before the dispute arose, where were you? Go back. Stay there. Matter will be decided. Then if you decide you tiger can eat, we will let you out and all. Right. That comes later. So this is called preserving a right. Already existing right is being encroached. Because conciliation proceedings going on, I cannot keep quiet. I can protect my right. Or I can even initiate arbitration where I want to preserve your right. Okay. So conciliation versus mediation, because conciliation sounds a lot like mediation, but in mediation, he attempts to guide the parties towards the solution. Whereas the conciliator acts as a facilitator, he intervenes, he gives them some opinion also finally. Outcome is an agreement. Here, see, the slight difference is at the end of mediation, there is a normal agreement, whereas here there is a settlement agreement which is filed with the courts, and the court gives sort of chop on it. The agreement reached by parties is a contract enforced by law, whereas the settlement agreement reached between the parties has the same status as an arbitral award on agreed terms. See, instead of the arbitration council giving the award, as she said, out of court settlement, like that, if it's an agreed terms before the arbitration council, same effect will be there for conciliation. It is executable as a decree of the civil court. That is why in India, thanks to Arbitration Conciliation Act, conciliation has got a slight high pedestal than mediation. Because at the end of mediation, you have only got an agreement. Whereas here you got an agreement which is like an award. It's an agreed award. Mediation is governed by Section 18 of the Code of Civil Procedure. Here it's Part 3 and all that you know. Mediation is governed by confidentiality. However, confidentiality in mediation is often based on trust. I told you, a trusted auditor, a trusted advocate becomes the mediator. Conciliation is bound by confidentiality. Extent, it's like arbitration. It's all secret, in camera. Nobody will know. Anybody breaching confidentiality will be liable to the other party for penalty, damages. If the agreement is, because the reason is this, there are huge companies with huge amounts involved. So they damage valuations. So if the agreement is breached, the parties would have to proceed in the usual process. Like any other, they will file a suit. Again, on that they may go out for arbitration also. But here, enforceable as an arbitral award. Okay, that is one thing about conciliation. You might ask me, what is the big difference between arbitration and conciliation? Thing is, between the two, this is early stage. Before you go for litigation or arbitration, you do conciliation. So you go for the initial steps, then you go for agreement. It's more proactive, more friendly, no rigid proceedings. It's not like a arbitral proceedings and all. You can come and talk, go. I've done mediation in my cabin where I'm now sitting. It's a slightly lengthy cabin where I keep space for everyone. One entire family will come and sit, and everybody will talk. I say, please wait. You talk. You finally notes. Then finally you go. Today you go. Come day after dawn. Come on Wednesday evening. Again they'll come. Then I will summarize what has been discussed. Then what is to be done, like that. Take easily 15 hearings, mediation, before we come to a conclusion. Same thing with conciliation. So we have come to an end to the topic. Okay. If you have any doubts up to now, especially on 34, I'll go back. 34 is very important. You can ask me any doubts. If you have any doubts, you can ask me. I'm just waiting. I'm giving you 5 minutes to ask doubts. Fairly simple topic, not much complication. Once you understand the basic principles, just have to remember them. Exam, you have to write them. That's all. It was quite great interacting with you all. I think this will be my last class. Beyond this, thank you very much, Pudi Benji. And so this would be my last class when I would be, handling these sessions for you. And it was a pleasure. I miss some of you here who are there from the beginning. They are not here now, but possibly others are here. Namrata ji is there, Purvi Ben is there, Chanvi, Prasant ji, all are there, Viraj Desai. Others, I'm sure, are here. It was great listening to you, and we would like to. No problems, and I'm sure I travel. Inshallah, I travel a lot all over India, and I hope. But recently, I was in Dharamshala, I was in Kangra. Just thinking, maybe some students could be here like that. So, love to. In case you see this ugly face, there might be a mustache later, but right now, due to certain reasons, I have to remove it. So, if you see my ugly face, kindly acknowledge me and just say hi, sir. You remember, I was a student. I would be loved to see you, and want to meet me personally. You have to come to Chennai, a place called Chennai in Tamil Nadu, South India. Have you heard of it? You have to come there. I live in a city called Chennai in South India. So if you're very particular, yes. Okay, don't worry. And wishing you all the best. And I pray to the Almighty God that every one of you should become a member of the Institute of Chartered Accountants of India very quickly. And not only that, be more successful in your life. Enjoy both happiness and success. And thank you very much. Bye. Class over, sir. Ji?